All right, we're going to go ahead and get started. Thank you, everyone, for coming early. We're going to get started with the Pledge of Allegiance.
Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, going to do a quick roll call here real fast. Ed Burrs is here. Paul San Francisco
Here.
Mike Lynch
Here.
Joe Silk
Here.
and Kevin Basquel here. We're going to go a little bit out of order here too, so I'm going to change a couple of the cases and how we're handling them. Yeah, so we will start off with case Z 2021-41. So I know we have a lot of cases here tonight too, so I'm just going to explain to everybody the difference between a party protestant and public comment. If you did receive a letter and wish to be a party protestant on a case, please state that at the start of the hearing. If you wish to make public comment, you'll be able to do so once we close out the testimony. If you receive the letter, again, you can be a party protestant. So, all right, let's get started then with application Z 2021-41. Radnor Chase Cronies, PO Box 490, Concordville, PA 19331, pertaining to the subject property at 3601 West Chester Pike. Property owner is seeking variance relief from section 172-123 in regard to the allowable sign area within the C1 district. Applicant is also requesting any other relief that may be realized during the zoning hearing process. Subject premise is located in the C1 zoning district. Who do we have here for this case? You want to just step forward? How you doing?
Good, thanks. How are you?
Just going to have you state your name and address for the record here.
Hi, my name is Karen Gravely. I live at 1410 Glenside Road in downtown. And I'm here to represent Pro Signs of Darby Signs, Pro Signs, and our client was this thing. And Pro Signs is at 251 Boot Road in downtown.
Yeah, but did you both swear the testimony you give will be the truth, whole truth? Your last name is Greenlee.
Greenlee, Greenle.
And your name again, sir?
Konchesky, KONCZWSKR.
Is your microphone on too? Is there a green light on there?
It's a red.
Can you just press that? Thank
And
you.
now it's green.
Go.
I'm 15. I live at 1513 Norman Road in Havertown. I'm with WSFS Bank from our headquarters at 1818 Market Street in Philadelphia.
All right. You want to take us through your application and what you're looking for here?
Sure. So we have a property at 3601 West Chester Pike that used to be the Bryn Mawr Trust Bank, and we are going to be converting it into a WSFS Bank. And so we have a signage proposal that is over the allowable square footage for C1 in the zoning code. You're only allowed 50 square feet as maximum. And our proposal is about 95 square feet, 94.67 square feet. And so do you want me to go through what the signs are or?
Yeah, why not?
Okay.
Take a look. And then what's the size of the current sign that's there?
So our current signs are a bit larger than our proposal. So originally, we were going to be doing a like for like replacement, taking down the BMT banks and replacing them with WSFS banks. And then we realized that we were quite a bit over. There is a variance applied to this property in regard to sign area, allowable sign area. And then also there's a variance applied for the wall sign in regard to the clearance from grade. It's a little lower than technically it should be according to the code. So there is some relief granted to this property for the BMT bank. That was from 2002. We have a copy of the variance in our application. I don't know if you can see that, but so what we did was we revised our original proposal from the like for like, and we brought it down quite a bit. We got rid of about 60 square feet of signs. Our proposal now is mainly for traffic safety, and then because we are on a corner lot, and I'm not sure if you're familiar exactly where that plot is, but there's 252 and then St. Albans Road, where it's sort of like a catty corner jig jag.
The Bryn Mawr Trust Building, right?
Exactly,
You guys
yeah.
took over Bryn
You know
Mawr
what,
Trust.
too, real
Yep.
quick, I apologize because I didn't
Sure.
actually check to see if we have anybody here wishing to make
Oh,
public comment or
sorry.
party protestant on this case. Is there anyone here? Okay, just public comment. So once we, yeah, at the end. And then Andy, the file's all in order?
File is in order.
All right.
Okay, so our original proposal was for, like I said, like for like. So what we did is we reduced our proposal a little bit. And so right now we're just asking for signs that we feel would aid with traffic safety within the lot. And then also because of where we are on a corner where you can see that it's a Wisvis Bank from St. Albans, from 252, and then from both sides of Route 3. So our first sign is going to be this pylon sign that we would like to replace the BMT sign with our new pylon sign. This is 34.67 square feet. It is a little bit smaller than our typical pylon sign. Wisvis has obviously quite a few locations. And so we do have standards. This is the smaller of the pylon signs in our standard. And then if you go on, this is about the foundation. And if you go on to the next one, then this is our wall sign that we're proposing, which is in the same general area as the BMT sign. This is 51 square feet. This again is one of our standard sizes. It's 36 inch high channel letters. And so these are the letters that you can see when you're on the 252 sort of side of things, where you can get a straight shot onto the bank there when you're turning on Route 3. And then the pylon sign is mostly for traffic coming from St. Albans, and then also coming west on West Chester Pike on Route 3 right out. So those are our proposed signs. And then we have two small directional signs. They're exit signs on the two curb cuts on St. Albans and then West Chester Pike. We originally had 5. There's 5 directional signs that currently exist on this property. Internal lot signs, circulation signs, I'm not sure what you call them, but directional signs. So we removed 3 and we would just like to replace 2 with Wisvis exit signs. So that's pretty much our proposal. But did you have any questions or?
Height of the sign you're placing on Bryn Mawr Avenue. On West Chester Pike.
Yep.
Is that the same height as the one that's currently there?
No, it is shorter.
Shorter.
Yes, ours is only 15 feet high.
How high is the existing one?
I knew the answer to that until I thought you might ask. I'm so sorry. I'm not sure I have that with me.
That's
I
fine.
can get it for you.
It's okay.
Originally, we proposed an 18-foot high sign. And so we've brought it down to 3 feet. And I know that 18 feet was more in line with what was there originally. So it's at least 3 feet shorter, but I don't have the exact number. I'm so sorry.
Is the reason for the variance total signage square footage, or is there a specific, is this in particular just total?
It's for the total
Aggregate?
square footage. Yeah, so you're allowed to have a certain number of square feet per linear foot of property that you have, up to 50 square feet. And our total proposed signs with the 2 interlot directionals, this pylon sign and the wall sign, we're at 94 and 6.67 square feet. So we're a little higher than.
Coming in less than what's there, right?
It is a lot less than what's there.
So the variance they had before was for more.
Yes, so so we do have a variance for, or the property has a variance, I should say, for the Bryn Mawr Trust signs that currently exist. And so they have approximately, so we've got approximately 25 square feet less than what they have currently. So they've got approximately 125 square feet.
What about, can you talk about lighting and, I guess, lumens is the proper term, right? Between what's there now and what you're proposing to put in?
I personally cannot. So I know that we have, there's electrical details for this, but I don't have the information of what is existing. I apologize.
The current sign lit, do you know?
Yes, it is.
New signs, same spots as the old Bryn Mawr, not putting them in any other location other than it presently.
That is correct. So we will have to put in a new foundation because the actual structural support of our pylon sign is different than the BMT pylon sign, but it'll be in the same place. So that one will be removed and then the new one will be installed. And then if you look at the wall, there's sort of that triangular wall that's right there on the front wall. And there's a decorative banding. And so BMT has their BMT and then they say Bryn Mawr Trust as like the letters all spelled out. And our channel letter set will sort of be right in the middle of that. Yeah, see, I'm not sure if you can see, but there's sort of like a decorative line. So they're above and below and we'll be right on it.
The location is essentially the same location
This-
as exists.
Correct. That is correct. Yes. And with the directional signs, they'll just be like for like exactly just pull the old one out, put the new one in.
Is there any additional questions from the board? So before we, since there is public comment, we'll close out the record on this. Just to explain too, for public comment, it's just public comment, nothing to engage in, just giving them the opportunity to speak. So
Okay.
I don't want it to turn into an argument or anything like
Oh,
that.
no.
So just take it in. So Ms. Wilson, right here at the podium. Is that microphone on? Is there a green light?
Now it is. Patty Wilson, 4111 Battles Lane. I'm going to note for the record that they are asking for a variance for signage. We have a sign ordinance. What they're asking for is actually significantly more than our sign ordinance allows. They are not entitled necessarily to this. What they are proposing is significantly louder in color and in character than what's there. Honestly, not attractive at all. And this community has been working very hard to show a character. So I do not believe, despite a variance that was granted before, this is a whole new application with a whole new set of people. I would urge you to turn this variance down. Thank you.
Thank you. Any other public comment? Right?
I'll approve the 2021-41 Radnor Chase Cronies for the variance.
Is there a second?
Second.
All those in favor?
Aye.
Aye.
Aye. All right, motion carries.
Thank you very much. Sorry, but I applied for a permit. So what is the next step? Mr. Andy, sorry. Hi. Oh, perfect. Okay, do you require any more information or we're good or?
I think you've satisfied all the information.
Okay, I was-
This was the last step for us.
I was hoping that you'd say that, but I just wanted to double check. All right, thank you for your help.
Thank you very much.
I know.
Have a great night.
I
Thank
thought-
you.
That's Andy.
I was like, I'm just curious. Yeah, it
I don't know
is.
how much we've done there. Yeah.
Stop anybody.
All right, our next application is Z 2021-42 for Chris DeFino, 233 Aronimink Drive, Newtown Square, PA, pertaining to the subject property. Property owner is seeking a variance relief from section 172-33B, subsections 5 and 6 for conversion of existing garage carport into additional bathroom and living space with covered porch. The applicant is also requesting any other relief that may be realized during the zoning hearing process. Subject premise is located in the R2 zoning district. Mr. DeFino and,
Scott Sampson, architectural.
all right, do you guys want to just state your names and address for the record to be sworn in?
Sure. My name's Chris DeFino. I live at 233 Aronimink Drive, Newtown Square.
All right,
Scott Sampson, 11 Amherst Avenue, Swarthmore, Pennsylvania.
And you both swear the testimony you
Yes.
or file in order.
File is in order.
All right, and do we have anybody here that is a party protestant on this case or wishing to make public comment? No one? All right, Mr. DeFino, if you want to take us through your application.
I was going to go through
That's
it if
fine.
that's okay with you.
And what's last name again? Sorry.
Sampson,
Sampson, all right.
yes. Thank you for hearing our request for a variance. Our issue here is that the Chris and Amanda DeFino's house is already encroaching on the front and side yard setbacks. What we're proposing to do is to convert, that's actually not the house, that's a, if you go to the drawings, you can see it. I also have the hard copy here, if that's easier.
First one, Z. Or Z11, yeah.
Tough to see for.
And
That's the site plan, and you can see the front yard setback is dashed in and dimensioned. On the left is the existing, and on the right is the proposed. What we're hoping to do is to convert an existing one-car garage and carport into living space. And what we're planning on doing is basically walling in where the carport and the garage is. And we're not, it's important to note that we're not going to be increasing any of the encroachment onto the front and side yard setbacks.
Just staying in line with what's there.
That's correct. That's correct. That's part one of our request. The second part of our request is that we would like to create a small covered entry porch directly over the existing front door. And while the first part of our proposal won't be increasing encroachment into the front yard, the second part, the covered entry porch will.
How many feet does that put between you and the street from what's there with the entry roof?
45.
Yeah, it's
45.
48'7".
Yeah,
48'8".
48.8.
48'8".
So just quick on this one. So if I look at the picture on the left, it shows the covered carport on the left. And so that's the area that's being closed in, but it doesn't come past the current
That's correct.
setback.
That's correct.
And then the front port patio, having a roof over the existing patio. The existing patio is already encroaching on the setback, but the
That's
house
correct.
structure isn't.
That's correct.
But this will encroach on the setback requirements a little more, leaving you with 48.5. What is it 60 feet? Yeah.
There is an additional drawing showing the elevation, the front elevation, so you can get an idea of what the covered entry porch is going to look like. We also, it's important to note though that the owners had some significant issues with the front door. It's located due south, and because there's no cover, the door has been replaced, and it's been the paint has been bubbling, and you've repainted it three times in an effort to reduce that, and it keeps bubbling. Another thing to note is that the threshold heats up in the sun because due south, and their son's feet have been burned on it. So what we're really trying to do is just protect his property and to make it a little bit safer. It's also an issue when you're coming in through the front door. There's really no shelter if it's raining or anything like that. If you're bringing in groceries or something. So we're mindful of the fact that it's encroaching, but what we're proposing is really very small and just enough to maintain some coverage.
On the coverage on the front door, pretty consistent in your neighborhood that people have done this.
It is.
In the
There's
neighborhood.
several people that have done it, and we do have some pictures showing houses on the street that have already done this.
Another thing to note is that Chris did go around and get a petition going and has 7 signatures, including, I think it's immediate neighbors.
So it's anyone that's within eyesight of my house, walked to all those neighbors, met with them, had conversations with them, and they're all perfectly willing to sign an approval of what we're looking to do.
what type, the existing carport today, is that, what type of structure is that? Is that attached to the house structure? Or is it
It's a
like
wood framed roof.
freestanding, separately purchased, that you just bolted to the house, or is it part of the structure?
It's part of the structure. There's a ledger board on the wall, and 2x6 rafters are coming down, but we're planning on sistering up to those rafters to increase the depth for energy code reasons, so we can get more insulation.
Making sure it's not like a, you know, purchased later, like and you're calling that a carport, but okay, fair enough.
Pre-existing setback, front setback, non-conforming as well?
Yeah, the house is as built right now.
Right, it's
It-
not 60 feet.
It's not, no. And you can, if you look at the site plan, you can see that.
I think it's 52 is what it looked like on the.
Sounds about right, yeah.
There.
So you're asking for a differential of 5 feet?
4'5". Correct.
I'll just
that-
share with the board. I mean, I'm familiar with the property. It's a quiet street. There's no I mean, yes, he's asking for a variance, but there's no practical encroachment issues, you know. And also just in going through your file, you want to share with the board your reasoning for going through the construction process?
Sure. My mother's, she's going to be living with us, and, you know, she's 73. So trying to create some, you know, living space for her and just a, you know, safe environment for her to get in and out of the house would be nice too.
I think it's also important to note that one of the reasons why we would like to infill that carport and garage is for accessibility reasons for his mother. And also the fact that there really isn't any other practical place on the property to do this. We're kind of squeezed on either side by setbacks as well as the front. So the only other option would be in the rear, and that would require ripping out a patio and an existing deck. Would also be potentially cost prohibitive.
I'll make a motion to approve application Z 2021-42 as stated.
A second.
All right, all those in favor?
Aye.
Aye. Aye.
Thank you.
Carries.
Good luck.
Yeah,
Thank you.
good
Thank
luck.
you. Good luck.
All right, our next application is Z 2021-44. Andrew and Jennifer Mataloni, 636 Golf Club Road. Pertaining to subject property, the property owner is seeking a variance from section 172-29B, subsection 5, to allow the expansion within the front yard setback. The applicant also is requesting any other relief that may be realized during the zoning hearing process. Subject premise is located in the R1 zoning district. So we have Mr. and Mrs. Matalini. Am I saying that correctly?
Mataloni.
Mataloni, I'm sorry. All right.
Close enough.
Just state your name and address for the record.
Good evening, Jennifer. Holston Mataloni, 636 Golf Club Road, Newtown Square is the address of our home. We're temporarily renting while waiting for the renovations.
All right.
Andrew Mataloni, same address.
Yes.
Andy, file in order. All right. And do we have anyone here that wishes to be a party protestant on this application or wishes to make public comment? All right. No one. All right. Take us through your application.
Thank you. We were here before in the summer seeking a variance, or I'm sorry, a special exception in order to complete some work on our house. Our house was involved in the storm back in June of 2020, and the trees knocked out a significant portion of the property. So the plan was we had to wait a little over a year for the insurance to give us something to get working. And at that point in time, I came before you, and we're trying to build a 2-car garage with a room above it, so our children have a place to basically hang out because we don't have a basement or the ability to finish at that. So part of our house is within the side setback, and we had requested and were granted the special exception. Unbeknownst to us, we haven't changed our plans at all. The plans that I submitted, the actual building plans, are exactly the same as they were at that time. Apparently there was an error on the part of the engineer who mapped it out. And as a result of that, we were unaware that the front of the garage on the left-hand corner was going to encroach on the front setback. After we were granted the permits, we had to go through the storm water process, and we retained Catania Engineering, and they redid the plans from scratch. And that was when we became aware of the fact that the left corner of the garage would be encroaching upon that 75-foot setback requirement. So we're here tonight asking for dimensional variance in order to complete the construction.
How much are you encroaching by?
And the drawing that Catania did, they didn't actually have the line going across. I did that just for a point of reference in the highlight. It's actually not as much as that shows. On the right-hand side, it's not encroaching at all. That's about 90 feet back from the right-of-way line. The left side, it's about 8 feet.
But nothing's changed in the building since you were here last. This is
Ever.
just a mistake.
No,
that
this
found.
this was a mistake. And basically what happened is the insurance company finally gave us a check. We had 24 hours to submit the permits, or we're gonna have to wait, or submit the application, or we were gonna have to wait another month. And the builder was just saying, plot the garage. And there wasn't, we didn't pick up on it until we had plans done again. And then we learned about that. So
Is it already under construction?
not the, I mean, we don't have the permission to start the garage. They started the renovations. We finally have a roof after a year and a half on a significant portion of it. But the front area, the front of the house, where the garage is coming from, does not have a wall. It's just plastic. And so we're kind of at a standstill we've been at a standstill for the last month.
Andy, do you have any input too on this, just to give a little background as to what's going on?
I mean, none other than the
Stern.
fact that, as Ms. Manaloni had spoken about, damage was done to her home based upon the storm. The permits were filed. We recognized that there was a side yard encroachment. We came here. And then I believe what happened is ultimately when there was a filing for the stormwater management system, this issue came to light, that the encroachment, if I'm correct, Ms. Mayor,
Correct.
this issue came to light. So in order to work cooperatively with these folks, we issued the permit partially to get them under construction to allow the damaged parts of their home to be rebuilt. This is an addition, so we had to come back here for that permit position.
Does the stormwater plan include
And
the updated garage dimensions or I guess the correct
the
dimensions?
stormwater plan is, the permit for the stormwater system is being held up until this is being addressed, but this is the last remaining concern, as I recall.
I believe the stormwater permit, it's already been filed over. Everything's been signed off and approved, and we already had it over at the recorder of deeds. So this is the only issue on this almost 2-year
The last
long
piece of-
dilemma.
Okay. Anybody from the board have any additional questions or concerns?
Do you remember how far, the special exception was, how far we were encroaching on the side yard that we granted the special exception for already? Do you have that number?
I don't have it with me, but it's not as far as the existing structure. I don't know.
That's fine, I'm just,
Yeah, you can't really tell from that drawing. The other engineers' plans were a little more descriptive with that side part because that was the issue at the time.
Right.
But part of our house was built was built in the 1950s. So the left side is actually within that setback area to begin with. And we're not going any further.
Is significantly within the side yard setback as it exists.
I'll make a motion to approve Z 2021-44 for the variance section 172-29B, allow expansion of front yard setback.
Is there a second?
Second.
All those in favor?
Aye.
Aye.
Aye. Motion carries. Good luck.
Good luck with everything.
Thank you.
Thank you. Thank you.
All right, next up, application Z 2021-45, Barbara Mathers, 3544 Winding Way, pertaining to the subject property. The property owner is seeking a variance relief and special exception approval from section 172-33B, subsection 6, and section 172-141F to allow the construction of an addition along the existing non-conforming side yard setback. The applicant is also requesting any other relief that may be realized during the hearing process. Subject premise is located in the R2 zoning district. Who do we have? Who's Barbara Mathers?
Barbara Mathers is the owner at 3544 Winding Way.
All right, and then who do you have with you? Just state your name and address if you're going
I'm
to be
Ken
going.
Mathers. I live at 14 Muirfield Court.
All right,
And I'm Win 4 at 14 Murfield Court.
Your name again?
Win, WYNN, 4 FOOR.
Oh, okay, everybody swear the testimony they give will be the truth.
Yes.
and either,
Barbara, ma'am, I'm sorry, you're Barbara, ma'am.
And Andy, their file is in order? And what, just asking what the relationship is here?
Yeah, what we're doing, my mother has moved over to Whitehorse and Wynn and I are going to purchase the house.
Okay.
So we're looking to apply for a variance for a non-conforming existing side setback.
That's fine. We'll get into that. I just wanted to know, just, you know, who was here. And your last name again was?
Mine's Mathers. I'm her son.
Mathers. Oh, okay, it's your mom's house.
And this is my fiance.
Okay, got it. All right, and do we have anybody here that wishes to make public comment on this case or party protestant? No one? All right.
Paid off the neighbors.
Ah, well, good for you. Take us through your application here and show us what you're looking to do.
Can we bring up, do I have control over that?
No, that's not- that's just-
Okay. I guess
That's the microphone in front of you. so-
if you could bring up this one with the existing property and the proposed addition.
Addition drawing, I believe it's called.
A lot of pressure.
Yeah. What we have is the north side of the property is an existing 10-foot setback. And we're looking to continue that setback and put an addition on the back of the house. We'd like to have first floor master bedroom with a master bath and expand the kitchen and then put a covered porch on the back. The only thing it's affecting is that non-conforming 10 feet on the side there. Both neighbors have given their okay for it. We'd like to open up the kitchen right now is very small, so we're looking to expand the kitchen, make it a little bit bigger. Have the foyer as an entryway into the house as opposed to the kitchen, and then open up the first floor to give it a little more open space. The master bath is backed up to the existing bath, which is very small right now. And then we'd have the bedroom right off of that master bathroom. So we'd have first floor living in a nice space. Just, we feel like it improves the property. It's a small, I grew up with, 5 kids in this house and the kitchen's always very small and everything's very small. So we're looking to give it a little more room on the first floor.
Rear setback is fine.
Yeah, it's more than 60 feet to the property line.
Essentially, what the question is the expansion along the existing 10-foot side yard setback. So they're looking to expand that along that same line, 28 additional feet.
So they're fine in the front and rear. It's this side one, just to kind of continue in line with that.
There's no violation in the rear.
Do we,
Just along this existing, one side yard.
And it just stays the same
Just
along the
yeah.
10, right?
Yep.
do we have anything from any neighbors?
I have 2 letters from the neighbors on either side of us
Okay.
stating their approval for
On
it.
the record here, I guess we have them in the.
I have
file. We
letters.
don't have to pull them up.
I
It's
submitted the
fine.
letters for them here.
Okay.
I also have a picture of the rear of the house if you wanted to look at that. We're looking to keep a little more open area behind the existing carport as opposed to centering this thing in the backyard. Plus, it's easier to run the plumbing and everything to the existing bath.
Mhm.
That's pretty much it.
Is this the only rendering that we're working off of, I guess, is there?
Where's the other? No, you
Well, I
have
have
that
other,
survey.
yeah, we have other pictures. We have the full survey.
Sorry, Steve.
Is there an elevation?
Yeah, that's what I'd be curious to see if you have.
I got a picture of the backyard. We don't have an elevation, but it's gonna be a 1-story. So basically the left side of that picture,
That's a 1-story addition.
1-story addition.
And that's where you're coming out there. That's,
Yeah, basically the kitchen would be coming off that big picture window.
Window to the,
okay.
And then the window to the left would be where the master bath is going to be. And then the bedroom coming off of that. So basically parallels the fence. And then some kind of covered porch in the back for a sitting area.
You guys back up to the park?
We're up the street from the park.
Okay.
We're basically at the top of the hill.
I got you. Yeah.
Was it ending, I guess, where this little,
Pretty much, yeah,
okay.
yeah.
Right there.
We're looking probably at a gable end as opposed to like a porch roof coming out.
Do you see any of the other houses that have done anything similar with building out off of the back?
Not really. Our next door neighbor is looking to put an addition on their back of their house. He said that he drew up plans for coming out the whole rear of the house. I don't
Why he
know.
wrote you that letter.
What's that?
Why he wrote you that letter.
Well, they have, what, seven kids living there, so.
Okay.
And the houses are, really old and tight, so.
These letters are both your direct neighbors?
Yes. The neighbor to the rear is, we have trees and a full fence, and we can't even see their house really.
But there's no issue with that setback, right?
No,
Said-
no, none at all. Should just be that side.
Any questions from anyone on the board? Any concerns, Andy, from your perspective? Any additional questions? Anybody want to make a,
I'll make a motion to approve application Z 2021-45 as submitted.
all right, is there a second?
Second.
All those in favor?
Aye.
Aye. Motion carries.
Thank you very much.
Thank you. Good luck with everything. I'm gonna go back to that. And yeah, and then back down to 5.5, so. We're still in here.
Yeah, it's over here.
So, all right, now we're gonna start back at the top of the list here. So application Z 2021-38, Thelma Cheune, 3552 Winding Way, pertaining to the subject property. Property owner is seeking an appeal from a notice of violation in accordance with the definition of family as it pertains to an Airbnb under the zoning definitions found in section 172-2. Applicant is also requesting another relief that may be realized during the zoning hearing process. Subject premise is located in the R2 zoning district. Am I saying the last name correct? Cheune? Choueni. Oh my God, it was way off. All right. So Ms. Choueni, if you want to just state your name and address.
Thelma Cheune, 3552 Winding Way.
And
Good evening, everyone. My name is Christopher Bagnato. I'm an attorney. I also reside in Delaware County and Newtown Square. I reside at 137 Ashley Road. Absolutely, absolutely.
all right, Andy, is the file in order? And do we have anybody here who is looking to be a party protestant on this application? Those are the people that have received a letter. Okay, so if you want to just stand up for now, we'll get you to at least state your name. You will have the opportunity to come up, sit at the table here, and you'll be able to cross-examine any questions. We're not looking for anybody to jump in, ask questions. We want to keep everything in order. So let's have everybody who does want to be a party protestant, let's get your name on the record right now. So please stand up, come forward to the podium. Anybody that wants to be a party protestant? Your name, address to.
Peter Foy, Peter Foy, F is in Frank, O is in Oscar, Y is in yellow, 30, oh, FOY. Yes, sir. 3550 Winding Way.
Mr. Foy, do you want to just stay here for a minute? We'll get all their addresses and you can swear everyone in one shot, I'm guessing. So just step forward, give your name and address to get it on the record here.
My name is Andrew Zahner. I live at 3549 Winding Way. Zahner, Zahner.
Stephanie Szymanski, SZYMANSKI, 3548 Winding Way.
All right, is that it in terms of, all right, so we'll get them at least sworn in. So any questions, once they're asked again, you'll have the ability to ask questions regarding the testimony that that person's given. Just again, to try to keep this all in order here. So, all right. And then anybody wishing to make public comment, once we actually close out the record, you will have the ability to make public comment before any decisions are made. Okay. All right.
So my name is Richard Sikora. I'm entering my appearance on behalf of the Township of Newtown. The reason we're here today is it's on.
No, Bat, turn it around. Sorry, just because I see this gentleman saying he can't hear.
Okay.
It's got to face you. Sorry.
All right. Better?
Yep.
So my name is Richard Sikora. I'm representing the Township of Newtown in this matter. This was a cease and desist letter related to the use of a residential property in a residentially zoned neighborhood as an Airbnb. The zoning code limits uses in residential neighborhoods to permitted uses as listed, which includes single family residential use and some expressly listed exceptions, such as professional offices under certain circumstances. You'll hear about that later tonight. But this is not any one of those permitted uses. This is a transient use. This is not we're not seeking fines right now. What we're seeking is just, so it's not punishment for what it has been used for. It's ceasing what it is currently being used for and to limit it to solely single family residential use as permitted by the code. That's why we're here. I bear the burden of proof. I don't know if anybody wants to, since I took the opportunity to do an opening, if you want to hear an opening from anybody else or.
Yeah, absolutely.
Okay, yes, all right. Thank you. So my client moved into this property in 2017 with her boyfriend. Her boyfriend passed away tragically. And so to supplement her income even a little bit, she started doing Airbnb. Airbnb, not all the time. This is not a commercial property. What this is my client living in this property full time. She goes on business trips a couple weekends a month. And during that time, she listed it for Airbnb. Who rents it out? And I would gladly send and show the listing to any one of you before you make this decision. Beautiful home. The people that rent it out are mainly people that want them for weddings and families across from Winding Way Park, if you guys know the area, which I'm sure you do. Those are the type of people that rent this place out. What we have here and what the township is saying, my township is also, is saying that they're in violation of the use and occupancy. What they neglected to mention was that my client got permission for the past 2 years to rent this property out with a permit. Only then, after one of the people were there, when they did a commercial for a kitchen appliance, I believe a neighbor called, and then they decided to say, you're in violation. That's what we believe. We also believe that since my client has never moved out, not leaving the property, it is an exception to the use of 105.7.9. Under exception D, any residential unit occupied by the owner, provided the owner provides proof of occupancy. She's on the deed, she's the owner. That is an exception, just to let you guys know. Other than that, we believe that it's really not a burden to the community. And we have evidence to store. We have 16 signatures from the 16 homes within the neighborhood of people that actually don't mind and welcome it. Again, if your concern is that people can buy property and just rent it out Airbnb 100% of the time, that can be alleviated by giving some sort of limit on the amount of Airbnb that's provided. My client is only trying to do it for a weekend or so a month to supplement of income due to the loss of her fiance. So, see if there's anything else that it also does benefit the township, and it benefits with the cost of the permits that my client has paid each for, not for 1 year, approved again, second year, plus the revenue for the township and taxes during this time. So it does benefit the township both financially, and it's not causing an undue burden. There's been no noise violations, no problems with tenants or anything like that. It's mostly, and I asked her, I was like, who comes to Newtown Square? Although it's a lovely place, I live here. I asked her who comes, and she told there's a nice venues in Ellis Preserve. The brides like to come, and they have the full house. This is a 2,300 square foot beautiful home, fully renovated. It's not the type of place where you go and you destroy and you cause problems. And that's all my client is asking for. A continuance of the permit that was already given to her and allowed by her. Thank you all.
can you, I'm looking at the code here, 172-2, and state how the tenants would not be, quote, purely transient, which is in violation of the code.
Well, the tenants, although they are there, they're only there for a very small period of time, but they're not purely transient because they are just there for events. It's like if you're going there and you're actually, there's no difference so much between that if you're going to Ellis Preserve, I guess, to get your hair done before a wedding. You're there for a few hours. These people are only there for a few hours, a couple days, a couple weekends, a month. So it's not purely, and again, I would gear you to see the exception that since my client occupies the property, that does not come into play. And these people are, it's not a place where these people are going into and backpacking areas and just staying like it's a hostel that you've heard those terms. Hostels are more commercial, meant solely for that purpose. This is a beautiful residential home where she allows people to stay. And she's an occupant at this home during this time.
So ma'am, are you on the premises the entire time that your guests are here?
Not all the time, no.
It's a wedding. Sometimes they like their privacy, understood. But
Yeah.
yes, she is there sometimes. Sometimes she's not.
Does
Is your-
Airbnb make you get the permit with the township if you're going to rent it through Airbnb? Is that a requirement?
Actually, the township asked me to get the permit. They said specifically because it was Airbnb, the exception that he mentioned that I wasn't able to get that. They said because the people that are coming are Airbnb, they have to make sure that it's safe. So I have to get inspections. I'm sorry. So actually the township asked me to get this permit. I did tell them that there's an exception that says if I live in the home that I shouldn't get a permit. And then they said that because it's an Airbnb, they have to come and inspect the home and make sure that it's safe, which they did. They came and they inspected the home and they said everything was fine. And for the last 2 years, we've been doing this and there hadn't been any problems until recently I got the zoning violation that says it's not allowed.
So I respectfully, I think we got a little bit away from just opening statements. I got some evidence that I could put on. I think it, clears up a lot of this.
Yeah.
They can then answer that and then you guys can have the questions. I think it might be
You're
easier.
right. The floor is yours. So.
Okay, so I'm just going to call Zachary Axt as a witness. Zach, you come over, sit next to me. I'm just gonna put my witnesses right here if
Yeah,
that's
fine.
good for you guys, and then
Throw that microphone in the middle, just.
You got it.
because we're
you
streaming.
got it. All right, so Mr. Axt, what do you do for a living?
Property maintenance inspector for Newtown Township.
Okay, are you a zoning officer?
I'm not.
Okay, what's a property maintenance inspector do?
Go around and inspect for life safety hazards.
How long have you been doing that job?
September 2019.
September of 2019. So when's the first time you ever heard of 3552 Winding Way being an issue?
Probably in the end of 2019, beginning of 2020.
Okay, so is there a process in Newtown Township for inspections of rental properties?
There is.
And is that a zoning issue or is that a property maintenance issue?
Zoning.
I'm sorry?
Zoning.
Well,
For the property maintenance.
Yeah, let's take a look. So if somebody wants to rent a house out to somebody, right? Is that what you do? Is that what you do? Do you do the inspections?
I do the inspections, yes.
All right. And they get housing permits?
Correct.
And they get, you heard the attorney on the other side mention the housing permit pursuant to section 105.7.
Correct.
All right. So section one, we don't have a section 105.7 in town, correct? We have a property maintenance code under section 127.
Correct.
And that adopts the International Property Maintenance Code.
Correct.
And then what we have done is amended a portion of the International Property Code, correct?
Correct.
And we've amended section 105.7 of the International Property Maintenance Code.
Correct.
Okay, is that the structure in our town regarding housing permits for rentals?
Correct.
All right, and is that the process that you oversee?
Correct.
And you're not the zoning officer?
I am not.
All right, so when you go in to inspect a house, are you looking for zoning purposes or for property maintenance purposes?
On just property maintenance and life safety.
Okay, and that's right in your title, right? Property
Correct.
maintenance. All right. So now in 2020, what's the first you learned about Well, I'll tell you what, let me just mark this as Township Exhibit 14. We're going to have a couple exhibits out of order. Township Exhibit 14, is that the property maintenance code that we're discussing?
Correct.
And on the bottom of the first page is the 105.7 housing permits?
Yes.
I'll pass this up in a little bit. Now, so you said you first learned of issues at 355 Winding Way sometime either in late 2019 or in 2020?
Correct.
Right after you first started?
Correct.
And how did you learn about this property?
We were getting complaints about noise and basically being a party house.
Okay. And did anything cause you to believe that perhaps the house was being rented out?
When we received the complaints, that's what the neighbors were saying to us, yes.
That the house was being rented?
Correct.
All right. And what did you do as a result of learning that the house was being rented and not being used by as opposed to just solely being used as the owner?
You sent a notice of violation stating that you needed to file for a housing permit.
Okay, a housing permit. And what does that do after you file for the housing permit?
Register it as a rental, and then we'll come out and do your inspection.
Is that the same process for anybody who rents a house
Correct.
or an apartment
Yes.
or any other type of situation where somebody else is going to be living in the house other than the owner?
Mhm.
Okay. And did in fact, Ms. Chune? Choueni, I'm sorry. Did Ms. Choueni respond to your demand that a housing permit application be filed?
She did not.
Okay, and what happened?
She sent a letter saying that since she resides in the residence, that she did not need the housing permit.
Okay, and so is that this letter here that we marked as Township Exhibit 2?
Correct.
All right. All right. And of course, this talks about the housing permit issue, right? It doesn't talk about zoning issues.
Correct.
All right. And as a result of receiving that letter, did that change your mind as to whether Ms. Chioun would require a housing permit?
No.
And did in fact she ultimately file a housing permit application?
Correct.
All right, and is that at Township Exhibit 3, a copy of the housing
Yes.
permit application?
Mhm.
Did she list the tenant?
No.
And just said varies, I guess, right?
Correct.
All right. Did that indicate it was being used as an Airbnb?
No.
In your scope as a property maintenance person, was it significant to you as to how it was being rented?
No.
Now, in 2021, did she again file a housing permit application?
She didn't file the application. All she sent was a check. It was just a mix up. I
Okay.
reached out and then she eventually filed the application.
Okay, and Township Exhibit 4, is that the housing permit application she filed in 2021,
Correct.
May of this year?
Yes.
And
Let them know. We'll let them know.
it says tenants, it was left blank, correct?
Correct.
Okay. A housing permit, did you issue a housing permit?
After it was just a renewal, we already did the inspection of prior year. So it's just renewal of her prior permit
And so the inspection doesn't occur every single year?
every 5 years.
Okay, and so there was an inspection done
Correct.
and it met the Township Property Maintenance Code?
Correct.
And a permit was issued?
It was.
Okay. Now, did you ever come to learn specifically that the house was being used as a short-term or transient rental property?
No.
Never?
The following when all the complaints started coming in the last few months.
Okay, so when was that?
I'd say October.
Of October of 2021?
Correct.
You became personally aware of
Personally,
complaints?
yes.
And what type of complaints did you become aware of?
That they're saying it was an Airbnb It's being rented. They kept sending us over the Airbnb page.
Okay.
And that it was being used for not only Airbnb, but also filming and commercials and stuff like that.
And who was telling you that?
Neighbors.
Okay. And did anybody have you go over to the property?
Yes.
And what did you observe when you personally went to the property?
When I went to the property, there was a film crew there.
And what date was that?
Who was film crew?
A film crew?
Film crew.
And just tell me what you observed.
I went to the property, there was a film crew there, lights, cameras outside, multiple people. I approached one of them, identified myself. They told me they were there filming a Dietz and Watson commercial. Dietz and Watson?
Like the hot dogs?
Yes.
So you physically observed that yourself?
Yes.
Was it, how many people were there?
10, 15 maybe.
Was there equipment there?
There was.
Was there trucks there?
There was a truck, a van, and there was a vehicle on the lawn that I had them remove.
Okay. And that was what date?
It was October 4th, I want to say.
Okay. And so you had to move that truck, and what did you do after you observed that behavior?
Went back and we discussed it with my boss, Andy,
Okay. And Andy, what's his job?
zoning officer.
He's the zoning officer. And what did Andy tell you? What did he ask you to do, if anything?
So we were discussing it and we went back and had a stop work order to stop all the filming going on.
Okay.
Stop work order?
Okay. And so you actually, was a document issued?
Yes.
Okay. And who signed that document?
Andy.
All right. Is that Township Exhibit number 7?
Correct.
Okay. So I'm going to, did you draft Township Exhibit number 7? Okay. Did you draft that document?
I did not.
Who drafted?
Andy.
So did you do anything with that document after Andy signed that document?
Only thing I did with this document was deliver it.
When did you deliver it?
The day after October 5th, I would say.
Okay. And did you observe anything at that time?
No,
All right. Did you ever go back to the property?
I did.
When?
October 13th,
Why?
there was a report of another film crew there.
Okay. And that was, now this
That was
document,
after this document.
Township Exhibit 7, which was the cease and desist?
Correct.
Okay. And
October 13th.
it was, and what did you observe at that time?
When I got to the property, there was a few vehicles in the parking. I approached a member that was outside and they said they were filming a video. They did not tell me what the video was. I then put a stop work order on the front door and let them know they had to stop everything right there.
And you did that at the direction of the Township Zoning Officer?
Correct.
Okay. And if we look at Township Exhibit 7, does that have anything to do with the International Property Maintenance Code?
No.
These are zoning issues?
Correct.
And specifically, this cites section 172-29, regulations for and permitted uses for residential areas.
Correct.
And it also cites section 172-2 for the definition of family, correct?
Correct.
And that's not anything you ever dealt with
No.
in your property maintenance role, correct?
Yes.
All right. I don't have anything further for you. Zach,
All right.
you can-
Let's do some cross here.
Yeah, you got to sit there. I don't have anything further. For you.
Okay, thank you. Well, briefly, I just have a couple questions for his witness. Can I ask
Yeah,
questions?
please,
Thank you.
go ahead.
Okay. So you met and spoke with my client in 2019, correct?
Yeah, 2019, beginning of 2020, I'd say.
And during that time, you guys talked about her getting a permit, right? For
Yes.
the property. And at that time, she was letting you know, and she let you know that this property was being used as an Airbnb sporadically,
No,
correct?
just as a rental.
Just as a rental.
Correct.
Okay. Okay, and isn't it true that you stated that you don't even really understand why that the township sent you to the property to get a housing permit?
No,
No, didn't you state that you figured that it was just an angry neighbor that's just causing a havoc?
no.
Okay, all right, well, that's your answer. I have no further questions.
To allow our party protestants, do you have any questions based on the testimony that Mr. Axe has given here? Anybody?
No.
Move on then.
Okay, so I do have marked as township, we've already identified township exhibit 14. I also have township exhibit 13 and township exhibit 12. 12 being just the code section on definitions, 172-2, 172-29, the use regulations for the residential district, and township exhibit 14, which is the property maintenance code we've already identified. I'll give just a copy of these guys. You already have this. I'll pass it up at the end.
And they're all marked, you said, right, for the record?
Yes.
And then,
Yeah, 13, 14.
while we're going through that too, anyone from the board have any questions too for Mr. Axe?
The first time you went there with the film crew, they told you it was for a Dietz and Watson commercial. Did they tell you what the second time was for? They wouldn't tell me that. Did you ask? I asked them.
Can you read these names?
Can I, Mr. Secor, can I just clarify for the non-attorneys here in the room? Myself included. So the applicant, and sir, I'll get your, I guess, response to this as well.
Thank you.
The applicant is making the case that because a housing permit was issued under the International Housing Code amended by the township, the section 105, subsection whatever, was amended by the township. So the applicant is making the case that because a housing permit was issued by the township under a home safety and property maintenance code, that it should allow, it is therefore permissible to continue in violation of our zoning code, 172, sir? Is that your position? The statement that I made, the clarifying point that I was trying to make was that, yes, you were indeed issued a housing permit by the township under the International Housing Code as amended by the township, section 105. Section 105 of that code was amended by the township. And you were granted that housing permit.
Yes.
And so are you making the case, or you'll allow you to make the case that that permit issued under a home maintenance and safety code is grounds for you to continue operating in violation of our zoning code?
That is one argument that is made and submitted to you guys, that the fact is for 2 years, the township knew and gave permission to my client and let zoning in their eyes go, that it was no issue with zoning. The zoning code is not specific as to Airbnb or any implicities as to what is being called for today. It was never brought up. So due to the omittance of them actually just letting it go, the omittance of them shows that they basically are okay with it. And as I was doing with my crosses, that we believe that maybe it was too much complaining going on. So they're trying to look for something. There's nothing specific in the zoning code about Airbnb. Everything's omitted. And then everything else we found an exception to.
Sure.
That's just one extra piece of evidence that we're putting forth that benefits for the board to realize that there really wasn't a problem here. And then if they want to say zoning now, we're still alleging that it's not a true violation of the zoning code either.
Does the township not have a responsibility upon learning, and I'll particularly draw attention to the transient nature of the tenants here. Does the township not have a responsibility upon learning that the use is indeed transient to investigate and, potentially give notice of violation?
The township does. They would have an ongoing responsibility, and we believe that they knew that this property was having an Airbnb at the time, and
Okay.
even when they issued the permit. And that's where the credibility comes in, because
Okay.
our stance is my client from the beginning let them know it was only a couple weekends a month, and you could tell logically looking at the property that it's not an empty place that you would rent out year to year when you have normal tenants renting out lease year to year. Usually those are empty, and it's a furnished apartment, and my client has always been living there. So I
Okay.
think that it's judgment for you gentlemen.
Well, I just want
Yeah.
to go back to Mr. Axe's testimony again under oath, that were you aware that it was an Airbnb or any transient type of rental agreement upon issuance of the housing permit?
No.
Okay.
Can I just add something, if that's okay?
Mhm.
Honestly, I did have a couple of conversations with Zach, not even just one. Maybe that's why I'm a little in shock. And all the evidence that the township is using today are things that I provided to them. The letter that they're talking about, when I talked to Zach, he wasn't even aware that there was a letter that existed, because I actually called his office a couple of times asking these exact questions you guys are asking right now. What do I do? When they told me about the permit violation, I had a conversation with them. I've had several conversations with Zach about this. I even told Andrew that I called his office several times. I mailed them the letter to try and have this resolved and have this conversation. And everything seemed to be fine. Even when he came to my house, I had the conversation with him. What do you seem to think the problem is? And he told me that I just think it's a couple of unhappy neighbors that might be, calling in and having complaints. He said, there's a book of complaints about you. Have you had conversations with your neighbors? Are you in good standing with the neighbors? So this is something that they were very aware of. When I submitted the application, I didn't put any names of tenants because I said it varies. If that was a question of who the tenants were, why didn't he question that? If anybody is submitting a permit application for rental with no permit, with no tenants, isn't the question, who are your tenants? So this also says that he was aware what was going on. And he actually is the one who asked me to do this, saying that it's a safety thing. When people are coming with Airbnb, we don't know who they are. We want to make sure that it's safe home. That's what they made me believe.
I just want to clarify and maybe differentiate once again that this was a permit issued under a housing permit under we're talking about apples and oranges, I think. And maybe the township can comment on that. Yeah, sorry, I'm talking too much.
No, you're great. So for the purpose of just clarifying for the board, and I don't know if they have the same questions or thought that I do. So when the housing permit was granted, that granted permission to rent the property?
Yes.
Okay.
Yeah, the housing permit, which you'll see in the exhibit that we handed up, that was an amendment to our property maintenance code. The idea is folks always take care of their own properties. Sometimes when folks rent properties out to other people, they're not quite as careful. So the township, of course, not all the time, but sometimes. So the township implemented a program that if you want to, and that's where most of their issues were coming with respect to health, safety, and welfare issues with rentals. So the township determined that it would be appropriate to issue a process under our property maintenance code. That if you wanted to rent it to somebody else, you had to register that property. And each year, file an application. And over so many years, there would be a physical inspection to make sure it complied with the property maintenance code. Does it have fire extinguishers and smoke detectors and GFI outlets? And, is the inside bare walls? Is there heat? Is there electric? All these types of things. That's what that inspection that Zach does. That's under the International Property Maintenance Code. As you know, we have a zoning code, which is entirely separate issue. That is how you use the property. So we do not dispute that Ms. Cheune can rent this property to someone. There's no doubt. What the sole issue is whether she can rent it to transient tenants through Airbnb.
And people that just come and go.
People just come and go. And there's a perfect.
Is there a link? I'm sorry.
I'm not smart enough to make all this stuff up on my own. I got a Pennsylvania Supreme Court case here, right? It's called Slice of Life LLC versus Hamilton Township Zoning Hearing Board. And the very issue of somebody renting an Airbnb, was it a permissible single-family residential use? Or was it a transient use? And the Pennsylvania Supreme Court said it's a transient use. The argument from the applicant was, whoa, you don't specifically exclude Airbnb. The Supreme Court said, you don't have to specifically exclude Airbnb. You just got to show, and I got one for everybody. You just got to show that what does that?
What length of term would make it non-transient? Like how long of somebody staying there?
Well, so when people are intending to reside there, things tend to change, such as your mailing addresses, your voting registration, your driver's license. You intend to set that up as your domicile. Vacations, right? 1, 2, even a week. I'm not sure exactly the terms Pennsylvania Supreme Court did, but that's clearly, hey, we're just popping in and popping out. We're here. And in the opening statement, hey, this is for a wedding party. Now, let's not forget, everybody, that there's two issues here, right? Because not only is it the use as an Airbnb, which is not proper under our code, but it's also commercial entities that are using this. We have film crews there, right, making commercials. And clearly, commercial activity is not appropriate in residential neighborhoods. Putting the Airbnb issue aside, so there's two issues that you're here before.
Is it uncommon too for somebody to submit their registration to basically rent a property without the actual tenant listed on there? Right, I mean.
I don't know how often that is.
Is that common that there's no one listed on there? Right, if I have a property, I decide I'm gonna rent it out, I don't know who it's gonna be to yet.
There should have been names on there.
Right, that does have to be on there when you're, okay.
Well, but I
Just
mean,
because you
if-
referenced that
but
there
if-
was
but if it's
blank.
I guess the question would be, if it's a empty rental unit, there is no tenant at that time, right? But
That's what I was getting at.
Usually there is, but it's not required. it sounds
Okay.
like.
So majority of properties in Newtown go through a rental agency, a realtor, even self, but there'll be some lease, there'll be some rental agreement, there'll be something. That kind of identifies the difference between.
that helps.
Zach gets the permit, it's, all right, here's the rental, but Airbnb is nothing.
I don't know exactly how it works, but I think you just go on, I've never done it, but everybody tells me I'm missing something, but you register online to use somebody's house for a very short period of time. I want to go on vacation, I can stay at a hotel or I can stay at somebody's house. And that's what we're saying. You just can't do that.
Typically, Zach would show back up as a tenant were to change out and somebody else were coming in, right? So 1 year, no, I'm saying in a typical rental, my 1 year lease is up. I have a new tenant coming in. Is he then showing up to inspect? None of that
Every 5
happens.
years, you need to
Okay.
get an inspection by Zach. it sounds
Okay.
like.
But
Some of the issues pertaining to this case law have to do with being part of the fabric of a community. Household has to be part of the fabric of the community. There can't be a profit motive behind this transient type of living. Airbnbs do, you go on, you register online, you can rent it for a day, for a couple of hours, for a week, whatever the case may be. That doesn't make you a part of the community. The definition that we have in our own code provides that it can't be transient. The court of Pennsylvania has ruled in this particular case that's been provided that it's not a permissible use. Transient leasehold, not a permissible use within a residential. That's consistent with our rule. I think that's the gist of it.
Okay.
And please remember, so we're not saying, look, you're a bad person and we're fining you for your use in the past for any confusion that she may have had as to whether this was permissible by our zoning code. We're simply saying you have to stop using it that way, right? So, all right, if they're, if this was if we're going into a court for a fine, I'm saying, Judge, she should pay a fine. And she's, well, if there was confusion. Well, confusion has nothing to do with it. Under no uncertain terms, as of October 5th, 2021, she's been put on notice that you have to stop using it, not in compliance with our zoning code. So even if there was a miscommunication, even if there is a misunderstanding, even if that was her understanding, maybe she had a reasonable belief it was okay. That doesn't change the fact that it has to stop because it's not compliant with our code. And so again, this isn't punishing her for what she's done in the past. This is saying, stop.
This is all their arguments. This is what they're putting forth. We're putting forth our arguments, but we're also putting forth, he said it, the fabric of the community, whereby we have evidence to show that the community is okay with this. These are majority on Winding Way and Road Street, which is literally right where my client resides. Fabric of the community, she is a member of this community and has been since 2017. She lives there majority of the time, and this is literally a couple weekends a month.
We have a copy of that?
Yes, please. I took
I
a
would
picture
like
of it.
to
You
see
can
it
have the
saved.
original.
Pass it down too.
And this is why we're here today. You are the decision makers. You guys are the trier of fact in this case. And it is a complex issue. And we're here today and where you guys can make the decision to allow her to continue to do this and allow her, even with the evidence to show that the majority of the community nearby is okay with it.
Everyone agrees that you can rent the property, and you explained
To a single family.
your definition
residential
of
use.
what that use is.
Yes, sir.
It states in our zoning that transient is not permitted, right? What is your definition of transient?
For me, my definition of transient is individuals who are there just for an hour or so, perhaps. You know, I've seen these things down the shore where they go and they literally don't even stay. You ever see them? It's like, hey, let me just wash and just do a shower real quick. I'll go to the beach. Something really relatively
Was it
quick.
one day or the hour? Like that's,
Something like that, you know, but not just like if it's a, you know, a family gonna stay there for a night or so and actually be there. And a lot of the time, my client is gonna be there as well with them. You know, so it's not purely transient. like that.
Now, if you just look at the slice of life case, though, it's really at the very end, the very last page, it's only a paragraph. On page 16 of 16, it says, the use in this case at bar is purely transient. Individuals rent the premises for a minimum of 2 nights and up to 1 week at a time. That's not me saying, that. That's the Pennsylvania Supreme Court telling you what transient is.
How many times would you say you rented the property in the last year, or how many tenants have you had?
It's usually on the weekend and it's not every weekend, so.
But I mean, I know, because I feel like we keep saying 1 weekend a month to multiple weekends.
Through your Airbnb rental history, so what's the number? How often does it happen?
I don't have that number
do
on me.
you, is it, you only advertise certain weekends when you know you're going to be on business travel, or
Right.
it only is rented whenever it just happens to be rented, and it just so happens that it's only rented a couple weekends a month? So in other words, is it listed to be rented every weekend?
It's listed to be rented on weekends when I'm not there, yes.
Only select weekends. If I go on now, it wouldn't say every weekend's available to rent.
It will say some weekends will be blocked off and the ones that are available will be available, yes.
Because of your planned business travel?
Yes, or I won't be in the house, then it could be rented on Airbnb.
How far out do you know that? Oh, sorry.
12 months.
You said you can rent it when
Yes, you can.
Okay. So you know your business travel schedule 12 months in advance?
No, not all the time. I thought you said how long can Airbnb be rented for, right?
I'm trying to, you said you rent it when you go on business travel, and that's to make income when you're not living there, right? But you have to list it to be rented X number of months or weeks in advance so that people can rent it and
So
select it.
how Airbnb works, it automatically is open for a 12-month calendar, but people don't rent that far in advance. I mean, most people just rent a
Right.
month
I'm
ahead
saying
or 2 months.
if a group of people rented it every weekend for the next year, went on Airbnb because you were just that busy and had that much demand, would you do that? Or do you only list it for weekends you're on business travel?
It would be available because I wouldn't know if I was going to be there. So yes.
That could.
Yeah, it could, it's a possibility.
Just
It's one
only
I haven't
happens to be
had, but
rented.
it's a possibility.
Okay. It's only rented a couple weekends a month because that so happens to be the demand that you currently have. Okay.
You know the individuals who rent from you,
I don't know them personally, no.
so you have a contract with Airbnb.
Yeah, so everybody who's Airbnb does checks on their identities and all of that. So it's not I who decide what the individuals are. It's Airbnb who decides who those individuals are.
You don't have personal contact with any of these individuals before they show up to reside in the house for a weekend or a week or whatever.
Yes, you do have personal contact because you have to talk about how to get in the house, exactly what to do. So you do have conversations with them before they come in.
Do you have any written contract or lease with any of these individuals, or you have one standard lease with Airbnb?
Yes, one standard lease with Airbnb and they,
You list with any other, is it exclusive on Airbnb?
it's on Airbnb and VRBO, which is similar to,
You have,
And VRBO.
yes.
you have two different listings, multiple listings on, yes, I could do it online.
Yes, you do it online.
And Airbnb does do a check in terms of a background check of all prospective people that wanted to would like to stay at the property. Just so you're aware of that.
And are these advertisements, they advertise for stays for what's the shortest period of time?
2 days.
2 days? And what's the maximum amount of time that they would stay?
I'm not sure what Airbnb's policies are, but since I ran out on the weekends, I only have experience with that.
In a given weekend?
So I'm
You said only 2 days, is it?
Yeah, so the shortest I do is 2 days.
So basically weekends, is that what I understand?
Yes.
And how many weekends per month would you say that that happens on a given 3-month period?
Where it's,
How many weekends a month? You lease it out?
how many weekends a month?
Yes. You,
Oh, okay,
on
like
average.
a single month, maybe like 2 or 3 times.
So 2 or 3 out of 4 weekends in a month.
Yes.
So the majority of the time is rented out. And these are multiple different people, are they not?
Yes.
Okay. Have any of your neighbors ever complained to you?
Not to me directly, no.
But you're aware of complaints?
Yes, because Zach told me about the complaints.
Okay. After these folks leave the premises after a weekend, do you have a cleaning service that comes in?
Yes, I do.
So that's on a basis of whenever you have these residents or people that come in, you get a cleaning service?
So I clean it every Sunday because.
Right.
they
Is that
leave on
required
Sunday.
under your contract?
Yes,
Okay.
yes.
What other requirements do you have with regard to the property for these rentals, short-term basis?
Through Airbnb?
Yeah.
You're just really required to be aware of the COVID regulations when it comes to cleaning and sanitizing and just making sure that all the bedding and the linen and the towels are cleaned and maintained properly, just so that you don't want to have people cross-contamination going on. And then for me personally, I just try to keep my yard and the appearance of the house very neat because I live in a family-based neighborhood and I just want to make sure that even with other people using my property, I still keep a very good standard of appearance for it.
Your rates weekend to weekend, they vary how much you rent the space for?
Yeah, so Airbnb has this algorithm that, for instance, if the Pope is coming into town and if the Pope is coming into town, then Airbnb will have less homes for people to use, so the pricing will change depending on the demand.
So it's an economic differential depending on if there's a big event going on in the area?
Right.
Okay. So you do this as for some level of investment or profit?
For extra income mostly. I honestly don't make enough to cover all of my expenses with it.
Have you ever had an experience where there's certain damages that are done to the premises as a result of these short-term stays?
Very rarely, but I do have some vases break for people who have children or things like that. Some knob, maybe I have a knob right now that fell off from a family that had a toddler, but mostly no, not really.
Do you do an inspection after everybody leaves for a given weekend?
Yeah, so I do an inspection just to make sure that everything that I own and have in the home is still intact and things are exactly the way I left them.
Have you ever rented the home on an extended period of time as per the original permit, like on a year-to-year basis?
I have rented it out for about 4 months, especially during COVID. When New York was experiencing the difficulty with COVID, I did have a family that had small children that wanted to get away. So they asked if they could stay at my home for about 4 to 5 months. And so since I'm a single gal, I was able to stay with friends during the time and I was home alone for most of it. So I did do that so that they can have a safe place to stay during COVID.
You're not suggesting on these short-term rentals that you reside in the same house with these renters?
I mostly don't. There are on occasion that I do stay with them, but most of the time, no.
Thank you.
Just one question. They said that there was complaints of noise, but have you ever received any type of written noise violation?
No.
Okay.
I just follow up with my witness and then okay, so Zach, what are your hours that you work?
8:30 to 4:30,
What days of the week?
Monday through Friday.
And so the 2 times in October that you physically went to the premises and observed the commercial activity, were you off duty on the weekend?
I was not.
Okay, when was it?
working hours during the week.
I have no further questions for Mr. Axe.
Is it your job to investigate noise violations?
We can bring out like decibel radios and stuff like that.
Okay, because we have in the record here correspondence from a resident describing her process of going through the Township Police Department, filing, essentially saying that there was excessive noise on the property, and that's here in the record. That's email correspondence.
Okay, well,
Can you speak to that?
yes, well, did you ever receive, or did any officer come visit you or any written warning or anything?
I've never received, I mean, and the township does have access to me, as you guys can tell. They do email and call me, occasionally. They've never sent me any complaints regarding noise. The only thing that Zach told me was that there are various complaints about you in the township, but no, they've never given me any written notice regarding noise at all.
Has the Newtown Square Police ever showed up at your door about noise or anything?
Not while I was there, no.
Is this your only witness, Mr. Sikora?
Well, I had a couple questions
Yeah.
for Ms. Well, so, I'm not sure if I'm
Do you wanna
cross-examining now or if
Yeah, I
this
was
is-
gonna say that
Do you
too,
wanna
because I know
finish
she
your-
hasn't been presented as a witness, and I also want to give our contestants the opportunity to ask their questions. Are we done with Mr. Axe here?
Done with Mr. Axe, but just hang in case something else comes up. And then as soon as this case is over, we can split. Okay.
Thank you.
All right. Is Ms. Cheune sworn in? Yeah. Okay. So,
You did.
Yeah.
You got her.
so you had indicated that, so you've used it as an Airbnb, ma'am, in 2020 and 2021,
Yes,
and with some frequency that you've already described, correct?
yes,
Okay. And you said that there's not really been any damage to the property.
no,
Is it fair to say that you really haven't had to fix up the property or make any major revisions over the last 2 years?
no.
Not fair to say that?
I mean, I haven't, when I bought the property, I completely renovated the house. Everything in the house is basically new, from the kitchen. So no, there hasn't been any renovation since I purchased the property.
When is the most recent time that you've rented it as an Airbnb or VRBO?
I haven't rented on VRBO. The beginning of the month was the last time.
Beginning of December?
Yes,
And do you still have it listed on Airbnb and VRBO?
yes.
And I just want to pass up two exhibits, Township 5 and Township 6, and just let me know if these are, in fact, are these just copies of your listings?
Six.
For question.
Yes, sir.
Township put a desist order in October, correct?
Yes,
Still renting in December, correct?
yes.
Are you aware of the cease and desist order, ma'am?
Yeah, but that's another, I
Can you
guess,
explain why you're still renting it?
confusion with, so basically they told me that I could continue and have a, I guess what we're doing right now. That's what I was under the impression of. So an appeal, they told me that, well, you can go ahead and appeal it.
Who's they?
Basically the gentleman who was sitting on our.
So
You see
I
it-
believe, just to help, I mean, you're referring to the letter at Township Exhibit 7, where it says, correction, Newtown Township requires that all unpermitted uses of the property cease and desist immediately. If you wish to resume the activity, yeah. Notice of violation from October 5th.
Letter from the township.
You guys have an extra copy of Township Exhibit 7?
Yeah.
You see that? What letter? I'm sorry.
Township 7?
Okay, thank you. Notice in front of property. This one, correct? Thank you.
But again, I'm not seeking to punish
Yeah.
Ms. Cheune for a violation of the zoning code. I'm seeking to have this board affirm the determination, sustain the determination of the zoning officer that this is a purely transient use and not permitted in our single-family residential district. Right? If you say that, then she continues to do it, that's going to be a separate issue where we're going to seek violations with the court. But I don't want to be distracted by, hey, did she comply with the cease and desist or not? I want to focus on the issues, the substantive issue is she allowed to do it or not? Because if you were to disagree with township zoning officer and me and the Supreme Court, then she would be able to continue to use it and there wouldn't be any violation.
And just so we're clear, that my client does allege that she states and spoke with the township, and those were the people that said, while you have a pending appeal, you're allowed to continue doing it. But you have to, once you go in front of the zoning board, they make their decision, and that's the decision. But if we do an appeal with the Court of Common Pleas or Commonwealth Court or whatever, and ask for a continuance with the court, that's the gist.
So I guess the answer to my question, though, that was pending, I passed up, I think it was Township 5 and 6, was it? The ads for Airbnb and VRBO, is that in fact printouts of your ads? Okay. And you do acknowledge receiving and having discussed the October 5th notice of violation that we marked at Township 7, correct? Okay. And you've already stated your position as to why you think you should continue to use the property.
Yes.
Okay. I don't think I have any further questions.
Is there anything else that you?
Further questions from Ms. Cheune?
All right, Mr. Bagnato.
Rich, do you have any other witnesses?
Just there's the next door neighbor.
We want to allow our party protestants the opportunity to.
We'll rest on our purposes of our side with the admission of the list of the neighbors.
Do any of our party protestants have any questions they would like to ask the witness based on the testimony she's given? Just anything she said that you have questions about? Nothing? Just, just go to the, actually, you know what? Come here next to Mr. Sikora, we were saying we do. Just turn that microphone on. Steve wanted to-
Stephanie Szymanski. Yeah, so my background, I'm an environmental engineer and a fire medic, high angle rescue person. And there was at one night, couple nights actually, but one particular night when you had a family there and you have this fire pit. And the flames were about 20 feet high. They were in the canopy of the trees above. You have pine needles on top of your roof. My neighbor's house is adjacent to that, right next to the, little bit back off of the fire pit. So being a firefighter, I'm concerned about that. So I went over to family and I said, please, you know, if they had small kids running around, I'm like, this is not, you know, what you should be doing right now. Do you have a fire extinguisher? Do you have a means to put this out in case it gets out of control? And so on and so forth. And they're like, well, we were told that we could use the fire pit. I said, is Thelma here? No, she's not. Have you talked to her? Have you seen her? No, we don't even know her. So at that point, we doused out the fire and just said, you know, have a good night, be safe. If there's any concerns, please contact me. I'm right next door. So anyway, that was one instance. Other instances, there was a party of teenagers, high school kids. There was no adult in the house. I've called, they were on top of the roof. They were running around in the backyard. They were trespassing on my neighbor's property. They were on my property. The police came. They knocked on the door. You could see people just scattering all over. There was cars. These are underage children that are drinking, doing illegal drugs. That I can smell. I can see it because I do have prior experience and knowledge in this. And again, where's Thelma? Not around. The police knocked on the door. They asked for you. They asked for the resident living there. You're not there. So if you're responsible for renting this house, or are you responsible for underage children drinking and doing illicit drugs? Getting in a car, driving drunk down the street. We have children, anybody. I mean, there's a lot of people that walk, you've seen them, people working out. It's like just the lack of disregard for that is just mind blowing, Thelma. I mean, I don't get it. You know, I would love to have you as a neighbor. You know, I would love to see some diversity in the neighborhood. I don't even see you there. I don't see you. You say that you're living there. I don't see you. I was working from home remotely for almost a year, having to go into the refinery back and forth. I do a lot. I'm an outdoor person. I work in the yard a lot. I build a lot of things. I didn't see you at all. Very, if at all, maybe once or twice. You know, so.
Mr. Mansky, I don't want to cut you off too rude too, but the idea here is for you to ask questions based on the testimony she's given. I don't want this to be where you
I
get
just
up
want to
and
say,
you
so
have
you're telling me
questions.
that you're there.
I actually do have.
Are you there?
Comments. The night she's actually talking about saying there was a neighbor, like guest that came over. It was actually, I had my sister Tam, who's sitting at the back. She actually came up to us. I don't actually believe she even knows what I look like. To be honest, this is the second time I've met her. She came over the first time when we had our hammock and she spoke to me. I believe she thought it was a family. The night she was talking about with the lights, I had leaves at the bottom of the thing of my fire pit and the leaves started to come up.
You were
and
not there.
I remember this night specifically. The leaves started to spark up. My sister and I, she's actually right here. She can speak about this. We actually were trying to put the fire out. She came over and said the statement that she spoke about right now. So I'm not sure what she's talking about, but it was me she was actually speaking about. If I wasn't there, I wouldn't recall this exact incident. She said she was a firefighter and all of that. And I do see her going up to her vegetable garden at the top of her hill that she has made with tin. So I actually know exactly what she looks like. Whether she knows what I look like is another question.
I don't think any of that's been under, you've admitted to renting it as an Airbnb. You're saying that because she's renting it as an Airbnb, it invites this type of behavior that you're describing.
Yeah, and well, she's saying that she's there, and that's the question. You're not, I'm saying you're not there.
Well, that's,
Where,
well,
you know,
really, I want to make sure we're getting to a question because that, again, to
well,
keep
isn't,
things
that's a
in.
question. I said, were
She
you
hasn't-
there?
she's
Were
been-
you there on these occasions? And
I
that,
believe
and-
I've answered your question.
has admitted.
She has admitted she rents it as an Airbnb and is not there all the time.
Well, and it wasn't you that one night of the fire. There's been several occasions of the fire. So
Thank you. Any other questions regarding the testimony?
My name, Andrew Zahner, 3549 Winding Way. My question was, I see weddings come in and come out. I see different license plates taking up parking spots in the park. I'm the furthest house. I'm pretty far away. I've been woken up several times. And I met you one time when I lived there for almost 9 years. When she bought the house, she was renovating the house. House looks beautiful. I met her once. I haven't seen her many times since. And I also do work outside. I'm also in and out of my house. I'm wondering as well how often you are there.
Well, I mean, it's really great to meet you, and that's a great question. I think one of the positive things that you could have done if you were looking to find out who I was, you've probably met me once outside, and I don't know if you came over to introduce yourself or say hi, but then maybe if we were acquainted, we would be able to see each other more. So
Can we please just try to move this along? He just asked the question. He just wants to know how often you're there.
I'm there every day during the week.
I'm just trying to move things along here too.
Yeah,
I don't want this to turn into an argument. He had a question. We just want to get
I'm
an
there
answer.
every day during the week, so you're more than welcome to step
Yeah,
by.
thank you. Anyone else before we move on here? And again, please just keep in mind, it's to ask questions based on the testimony that she gave. We're not looking for this to turn into a huge argument here. Just please keep that in mind when I bring you up here. Thank you. All right.
That's me. I'm Mr. Foy. Please state your name and address.
Sure. Peter Foy, FOY, 3550 Winding Way.
And has he been sworn in? Yeah. Okay. So do you live, where do you live in proximity to 3552 Winding Way?
Right next door.
Okay. And over the last 2 years, have you observed anything with respect to the use of the property that causes you concern?
Several different instances that have caused concern. With the rentals, we don't know who's going to be there any given weekend. With the film crews, the community has had issues with that. Even with the past rental, they've actually blocked streets during the pandemic when we were pretty much on quarantine right when it began and shut down. There were multiple parties during that time. This picture is actually.
Hold on. Do you keep talking? I'm just getting this set up.
Sure. So even during the pandemic, there were multiple parties during that time. And the reason why I know is I was partially furloughed. I work for a medical system. So I was working from home at that time. And my family actually had to move out because I was on COVID positive floors. And during that time for about a month and a half, it was pretty much a nonstop parties. I believe that was when one of the parties where there were children on the roof. Another party, we had to call the police because people started parking in our yard. And then we watched as there was a substantial number of looked like minors waiting for their parents to pick them up after the fact, and people were walking across our yard. We've had things broken in our yard. The list is pretty substantial. I mean, at one point I did had to send a letter to, I believe, the local EPA for the contractors that were hired were dumping paint in between our houses.
Okay, that didn't have anything to do with the Airbnb or
No.
VRB, right? Okay, so we'll start like, yes. Sir. Yes, my list, sorry. So got my hearing outline. It's going to be tough to ask the next question. So I put two photographs in front of you. Gave one to Ms. Cheune and gave it to the board as well. I think we have township exhibits 9 and 10. Can you just explain what each one is?
Sure. So 9 was recently this past weekend, and I actually took a picture at the moment because I actually didn't believe it was happening. This Charlie Works bus actually
blocked the road. As you can see, across the street directly is the park and the entrance to the park. The trolley is actually blocking the entire street. And that was at least for about 10 minutes, to the point where people were actually driving their cars into the on-ramp into the park to go around. And that was going for both directions, both ways. It was pretty much accident waiting to happen.
Was there any indication that Ms. Cheune was in any way involved with this wedding?
None, no,
You didn't see her at all?
no, sir.
Bridesmaid dress or wedding dress or anything?
No, sir.
Okay. Did you see the other people who were involved in that party?
I saw a couple of the people, but that, again, it was more when I saw this happening, that's when I took the picture.
What's number 10?
Number 10 is the largest of the film shoots that occurred. And they filled up that parking lot, continued to park throughout the community, which is when I believe there was a phone call made to the township at that point in time, just because at that point there was complete disregard from the film crew, just walking across the street, stopping traffic at one point, also leaving the trucks there. So even when the grounds crew came to mow the pond across the street, they had to park on the street. They couldn't actually get into the park. Also with the township park use only, that all those spots, nobody could actually enjoy the park if they were coming from outside of our community.
And when you're showing those folks, they're across the street, they're not on the subject property that we're here about today, right?
That's 100% correct.
But those folks that you observed in the township park with that truck, you also observed those same folks going in and out of the Airbnb house?
That's correct.
I don't have any further questions.
Mr. Bagnato, any questions for his witness here?
So your testimony is this is from this weekend, this past weekend for the one that looks like a Philadelphia Trolley Works picture?
Or number 9, yes, sir.
Number 9, okay. I mean, do you remember that the people that stayed this past weekend were elderly people from a church for a dinner? Did you see that? Any other people?
All I saw was I saw a couple people. It's not really my job to manage a next door neighbor. But what I saw is I took the picture when I noticed that it was blocking traffic throughout the community, and there were honks, and there was no movement at all.
Did you see this trolley pull into the driveway of that property?
It never moved into the driveway, sir.
Okay.
Did anyone come out of the house and go into this trolley or vice versa?
I guess it loaded up and then they left. It seemed like there were people in the windows. I don't know if you can see people in the
From the
windows
house, though?
there. From the house, yes, sir. That's what it seemed like they were picking up people from.
Saw them leave the house and get into the trolley?
I saw people moving back and forth.
And what's the date of the number 10, if you recall, with the people hanging outside?
I do not have the timestamp is not on this picture, actually. I would have to look that up. Give me one
Oh,
second.
that's okay. Don't worry about it. It's fine. I have nothing further.
Any of our,
Nothing further from me.
and any of the party protestants have any questions for?
I just wanted to add one more statement. That's okay, sir. So we actually didn't want this to happen. My wife actually did reach out to Thelma. And at that point, my wife was yelled at. I am on the phone and Thelma proceeded to walk inside. And my wife was actually trying to be quiet to get her attention because she realized she was on the phone, but that reaction, as either we've received either silence or reactions as of that. Thank you.
Any questions for Mr. Foy from our party protestants? Nothing? Okay.
Question for Andy. Andy, they keep mentioning police. Do you have police reports, or have you been aware that there's been police activity at the
We were
property?
certainly my office was certainly made aware of police reports. And then we would follow up when it affected, when it occurred during our work schedule.
Okay, thank you.
I mean, again, this isn't a criminal, we're not trying to cite her with anything. We're just, this is the neighbor next door who would have called the police. Calling the police didn't seem particularly helpful.
Hearing off of the police report. Did you ever receive any? Just gearing off of the police reports, did you ever receive any police reports or anything?
No, and I've actually called the Newtown police when I found out that I had complaints regarding, all these, I guess, allegations. And they told me that I should fill in need to know, which I did, and they denied. So no, I haven't been aware of. Right to know, sorry. And which they denied. And I haven't been able to do that.
Okay.
I guess we're further done then with
I'm
this witness. Any additional witnesses?
No, sir.
We want to get to our, any
Any
closing
additional
arguments
witnesses?
here?
I'm
Any-
gonna have you ask my
I mean,
sister.
I'll do a
what
super,
happened
super
this
short
past
one,
weekend.
which is,
Oh,
Sounds amazing.
we have one witness, just as
Oh.
her sister.
I asked,
Yeah. You want me to call back? You want to call her?
Tam,
Tam? Okay.
ask her what was happening this past weekend.
Oh, okay.
will I hang here?
you can step back. Thank you. Thank you.
Close out the record.
This is, it was a wedding.
Once this record's closed, we'll get to public
Just
comment.
remind,
I mean, I just have,
Just so everybody knows, we will get to public comment when the record is closed out. It's not forgotten, so
I
I
mean,
just want to
yeah.
close out their testimony.
I just have one question as to what, are you aware as to, yeah, swear in, yeah.
I do.
You actually know your name.
Mexico.
Yeah.
Yeah,
Yeah.
CAM. Mexico, MA,
She was there, but she was.
What's your relationship with my client?
She's my sister.
Okay, I
Older
just,
sister.
you heard testimony today about what occurred this past weekend. Can you elaborate on that? What, to your knowledge, occurred this past weekend as terms with the
Yeah, we
guests?
actually hosted a family dinner, Christmas dinner. I actually have a picture that I took after.
Speak a little bit louder.
Sure. So we had a family dinner, which was myself, her, my aunt, and the kids. Actually, after I had set up the dinner table, I took a picture at 5:35. I have it with me on my phone.
Okay,
Okay.
all right, that's all. Thank you so much.
Is that it? That, okay.
So I want to make sure before we wrap up, we have identified Township's Exhibit 2, 3, 4, 5, 6, 7, 9, 12, 13, it's 14. The property maintenance code, section 127-1. Let's move for the admission.
Are admitted.
And I didn't say that on the speaker, so I'm going to say it on the speaker. I'm just moving for the exhibits identified. And you said they're
They
admitted.
are admitted.
And so my very brief closing argument is I submit to you, it really doesn't matter if Ms. Cheune is there some of the times when the Airbnbs or the VRBOs or the other transient uses or commercial uses are happening. They're not permitted uses under our township. She wants to live there. There's nobody complaining that she can't live there and that she wants to rent it out to a single family residential use. There's nobody complaining that she can't rent it out for a single family residential use. Airbnb, VRBO, television commercials are transient, non-residential uses. Township 7, which is the notice of violation, dealt not only with the transient use, meaning VRBO or any similar type of use, it's also just the general commercial use of the property for film crews. I mean, that's not what's supposed to be happening in residential neighborhoods. So there's two types of zoning violations that we're here about. And we're seeking that you deny the appeal, affirm the determination of the zoning officer. Thank you.
Sorry, playing with that light all night, right? I'll be brief in terms that you've heard our testimony, you've heard our evidence, and you've heard the support of the surrounding neighbors as to what is happening with this case. My client, as we said through the law, is that she is an occupant of this property and really truly has not caused much stir as to what is happening. We believe that it's possible that my client should be able to continue to have the Airbnb because for the past 2 years, she was able to have this permit. She was given this permit. And in terms of a transient nature, we argue that it's not purely transient in terms that my client, as again, she's occupying the space and it actually can benefit the community as well. And it has been for the term of the permits that were paid for by my client for this period of time. And that's what we're requesting today. Thank you for your time.
I guess there's testimony is the house was fixed up. No action, money spent, alteration made to use this property for Airbnb in reliance on erroneous issuance of the housing permit, of the zoning permit. So it's not like there's a variance by stop.
Good. All right, so we'll close out the record and open it up for public comment. When you come up, we'll get there. Just give your name, your address, and make your public comment. I'll let you seem very eager, so get up here. Come on up to the podium, make sure the microphone is green. Yeah, we'll make sure everybody gets the opportunity
Hi.
to make a comment.
Make sure that green light is.
Yeah, it's on. Elizabeth Scott. I live at 205 3rd Avenue in Newtown Square. I just had a question. I was looking up, just out of curiosity, how many Airbnbs were in the area, and there's 300 listed in the area. And I was just curious on how many permits are actually issued.
That's not something that we as a board
But I
would be
mean,
able to.
like, how many come before the board for this?
This is the first I'm seeing in my time here. so.
Yeah. I just thought I.
Yeah,
Or would
raises
you-
a valid point that there's 300 listed Airbnbs in this area.
We did close out the record. We're doing public comment here, so. Anybody else with public comment? Please state your name and address for the record.
Hi, my name is Caitlin Foy. I live at 3550 Winding Way. Personally, I'm saddened that it's gotten to this today. As a next door neighbor, I have reached out to you. I've been doing some fact checking in the back, and I'm a little concerned that not all of your responses have been accurate. I'm not sure that all responses have been accurate. For example, did you know of any noise violations? You said no. I know I posted at least 2 through Airbnb neighbors, and that was something that you received. It's really been trying. I know that I've met most of your Airbnb renters because they park in my driveway. They park on my yard. They walk into my home. It's a lot, okay? So just letting everybody know, the people that come to the house, I know you're making light of it. Oh, it's just people coming for weddings. It's more than that. It's party goers. It's people doing illegal things. And I believe you. I believe that you don't know about a lot of the things going on because you are never there. You are never there. And if we did a little background check, I wonder if there's not another residence where you reside, because I sure as hell don't think your primary residence is the 35521 Winding Way. I said, I do not believe that you are primarily a resident at 35521 Winding Way. So it has been a detriment to the neighborhood. And while you say it hasn't been a problem for years, it has been. We are a kind and patient community, but we have had enough. And we feel that our kindness has been taken advantage of. So thank you.
Thank you. Anyone else for public comment?
My name's Derek Lemke. I live at 110 Beechwood Road, Newtown Square. DEREK LEMKE. I live on the adjoining road to where your home is. Initially, I was excited because I saw that there was progress on the house. It was renovated and the house looks fantastic. Unfortunately, we've never met, and I drive by your home minimally twice a day, going to work or coming back from work. I would say I've seen you probably less than 5 times in the 3 years or so since the house has been renovated. So I would challenge the comment that you are there regularly. I do not see you. You may be, I don't see you. I think our neighborhood has been tolerant of potential renters, but I think that has been taken advantage of. And when I have film crews and catering trucks and
sound people and lighting people with cars parked in front of my house, 6, 7 houses away, with a school bus coming down the road, it just adds a question mark of, is this house being used for people coming for weddings? Or is this house being rented out and being used then for commercial purposes, which from what I believe I've understood is not allowed through our township ordinances. So from my position, it seems as if the house is being used for something that it's not supposed to be used for. And as a neighbor who's been here for 12 years, that's concerning. And it's gotten to the point where I feel like it has to come to a stop. Thank you.
Thank you. Anyone else for public comment? All right.
I'll make a motion.
Yeah, if you want to make a motion, go for it.
Yeah, I feel like the applicant and council failed to adequately prepare and make a case for this applicant, for this appeal. And I believe that this is a gross violation, a clear gross violation of our township zoning code. And I make a motion to deny application Z 2021-38.
Is there a second?
I'll second.
All those in favor?
Aye.
Aye.
Aye. Motion carries. Sorry. Yeah. Yeah, go ahead. You got a couple minutes.
Your second?
I do.
We're gonna just give it,
He has to change his paper.
we'll be back in a couple minutes.
They went for a break.
Thank you so much.
Are we, everybody ready to get started? You good? We're here too.
Do you want to just set up? Just, you know, Tom, sit up front. Yeah, but I got, seriously.
So plug in.
There's plug right here.
Tommy, help if you turn the hearing aids on.
Do you need help, Tom? Dude, I tried.
Check, check.
Here we go. You good? My God.
Absolutely.
All right, we're gonna get started here, everyone. We have application Z 2021-40 Craft Custom Homes LLC for 3rd Avenue, Newtown Square, pertaining to the subject property. Property owner is seeking variance relief from the lot area and bulk requirements of section 172-34B. The applicant is also requesting any other relief that may be realized during the hearing process. Subject premises located in the R3 zoning district. So who do we have here on behalf of Custom Homes?
Hi, good evening. Deborah Schultz speaking on behalf of the applicant.
Just make sure those mics are on.
Certainly.
And your name, sorry?
Ryan Alexaki, Craft Custom Homes.
Do you want to swear them in then?
I do. ALEXAKI.
And Mr. Sikora?
Here on behalf of the township, who is going to participate as a party.
Okay. All right, and Andy, is the file in order on this?
File is in order.
Okay, and do we have anyone here who wishes to be a party protestant that received the letter that is able to go on the record as a party protestant? Okay, so we got a lot of names to get here then for you, Tom. You want to get them all now then? And okay, so just come up, give your name, address, stay there so we can swear everyone in at the same time.
Diane Riccio, 209 4th Avenue, Newtown Square. RICCIO.
Diane, Diane.
And just,
Just move
got a
over.
long line behind you.
Okay.
Alexander Pondok, Pondok. I'm on 203rd Avenue, Newtown Square, PA.
Ray Massey, 203 4th Avenue. MASSI.
Gregory Scott, 205 3rd Avenue.
Bill Riccio, 209 4th Avenue. Riccio, RICCIO.
Elizabeth Scott, 205 3rd Avenue.
Martine Gallagher, 208 3rd Avenue.
Christine Gallagher, 37 Radnor Drive.
Neil Doherty, 148 Beechwood Road. IALL. Sorry.
That's okay.
Doherty, DOHERTY.
Robert Stidham, STIDHAM, 308 4th Avenue.
Sue Cordes, 147 3rd Avenue, Newtown Square.
Jim Tregear, 156 2nd Avenue, TREGEAR.
Tricia Tregear, 156 2nd Avenue.
Bridget Doherty, 148 Beechwood Road.
Does everybody swear the testimony they give? Sorry.
If I could just start and give the board a very brief overview before we get into the testimony, and then I'll distribute some pre-marked exhibits that I have. The genesis of this application, we think actually is pretty straightforward. We're simply seeking a dimensional variance to permit a decrease in the setbacks, which are really necessitated by virtue of the existing conditions of the property itself. The property has several unique constraints, non-conforming lawful constraints to the property. First, it has a lot size that is very undersized, it's 4,800 square feet, whereas this particular zoning district allows today, under today's ordinance, for 12,000 square foot lot size. In addition, the width is non-conforming. The existing lot width is only 40 feet, and under the ordinance, 80 feet is required. And the third nonconformity is the minimum contiguous building lot area, which is also 4,800 square feet is the existing area. So the property.
Can we not do this? Let's just let them,
But it's not a building lot.
but I said this earlier. I said that you will have your opportunity when she calls a witness. We're not just going to jump out of the crowd and ask questions.
No, I was
It's not we're trying to keep things moving along here.
So I was saying there's these non-conforming conditions of the lot, which, as this board is very well aware, they have a correlation to the ultimate setbacks and other area and bulk requirements, given your typically your building coverage and impervious. So that we're not seeking relief from any of those. It's strictly as to the side yard setback. The courts in Pennsylvania, it's pretty clear. They have ruled that the fact that a property has nonconformities in and of itself is a uniqueness sufficient to support a hardship for purposes of a variance. Here, as I mentioned, the lot size and the lot width really is what's dictating ultimately what could go on this property. Essentially, you'll hear testimony from the witnesses that you'd only be able to place a 5-foot wide building on this lot if you had to comply with the ordinance under today's standards. So the first relief that we're asking is for a dimensional variance. Secondly, and I don't think that we need a variance from this, but we're seeking an interpretation that the existing nonconformities that currently exist that are not being changed are permitted to continue. Your ordinance does have a section on your nonconformities that you're allowed to continue your existing nonconformities unless you're extending them or further encroaching in them. So we would ask that the fact that the lot size is nonconforming, as well as the lot width and the minimum contiguous building area, that those be deemed to be a continuation of an existing condition. And the alternative, we would be, to the extent you didn't agree with that, we would be seeking a dimensional variance from that as well. And then third, This was not actually included as part of the application, but you certainly have jurisdiction under your powers to consider this. To the extent that this board grants favorably on the application, we would be seeking an extension of your normal, what I call the sunset provision under your code that states that within 6 months from the time of your decision, you have to obtain a building permit. We would be seeking that to allow it to go for 12 months, just given, as I'm sure you've heard on other applications, with supply and demand and building and get materials. And by the time, it's really difficult. 6 months goes very quickly. By the time you do your grading permit, your stormwater management, design that, and you submit for your building permit, you're probably already looking at close to 9 months. So should the board grant this application, we would be requesting that as part of it, that you extend that period to allow a 12-month period from which to obtain the building permit. So if the board has no initial questions, my first witness would be Ryan Alexacki, and he would testify on behalf of Standing essentially and give you a little bit of background about the application. And before we get started, I do have some, I believe everything's up electronically too, but I have some handouts.
Mr. Gospel, as a party protestant, do I not get a copy of what you just passed out?
We're gonna have to go off what's on the screen. I mean, we have how many party protestants here?
But at least one of us should have it.
That's fine if you want to pass it around.
I'm sorry, I brought 10. I thought that was more than sufficient.
Yeah.
Can I ask a question
Sure.
too? Is it common practice to list one variance relief request in the legal notice and then come to court prepared to discuss other variances that us didn't have an opportunity to review prior to tonight?
If I could just respond to that, the section in the notice that was cited encompassed everything that we, to the extent that we need those other variances. There was interpretation, but that section of the ordinance was listed in the notice. I will say, though, that the law provides that you don't need to specifically state what your relief is. You really just have to put the world on notice of what you're proceeding with, so they have the opportunity to come and learn more about it. Quite frankly, most lay people don't know the difference between a special exception and a variance, so you really don't need to specifically identify every provision of the ordinance.
That was Mr. Mass, yes.
Well, let's continue on here, so.
I'm asking the board, is that common
I,
practice?
we're given our agenda that is put before us because we are a judiciary committee, so we're not given much prior to this. And actually, I don't know if this is something that either Mr. Neese would handle or Sam in terms of how that's.
Well, from reviewing the application, I think it's sufficient in terms of what the nature of the requests are. And she has outlined exactly the alternatives to the interpretation. I think that's amply put forth in the application for tonight's hearing. So I don't think there's violation there.
Move forward with your witness.
Thank you. Mr. Alexacki, could you state your name and address for the record, please?
Ryan Alexacki, 1549 Dowling Forge Road, Downingtown, Pennsylvania.
And with whom are you employed in what capacity?
I'm the owner of Craft Custom Homes.
And you're authorized to speak on behalf of Crest Custom Homes this evening, is that correct?
I am.
Can you please give the board and audience some background about Craft Custom Homes and what types of projects you typically build?
So we develop residential and commercial projects in the surrounding counties and municipalities. Currently, right now, 56 lots in development. And we build approximately 20 homes a year, many of which are on what we call infill lots in existing neighborhoods, such as this. The other aspect of that would be, small subdivisions, 5 to 30 units.
And I'm going to refer your attention to Exhibit A4, which is an aerial Google Earth plan. And can you please identify the property that is the subject of tonight's hearing?
So if you look directly south of the marker, right there, and directly to the right of the 2.5-story colonial to the left, That is the building lot that we were discussing, in between the 2.5-story colonial home and then the home on the corner property.
And all of the surrounding properties are single-family homes, correct?
As far as I'm aware, yes.
Now, referring you to Exhibit A5, which is the existing condition plan, can you please explain the existing condition of the property and including any unique characteristics of the property itself?
So the property is 40 feet wide, surrounded partially on several sides by fencing belonging to the neighbors, similar in size to the surrounding parcels to the right rear of the subject property that we're talking about.
And does that exhibit demonstrate apologize, I think one of my exhibits may have been I'll come back to that in a second, I'm sorry. The engineer is going to explain the project in more detail, but could you give a general overview of what you're proposing to construct on the property?
So we are proposing to build approximately a 25-foot wide, 38.5, roughly 2.5-story colonial style home. Similar stylistically to the house to the left of us, which is a little bit wider because the garage sticks out to the side. But from an architectural standpoint, would be classified as the same.
And is 25 feet the standard size home width in today's industry?
Generally speaking, that would be for this type of lot, the minimum size width that you would be looking to build.
Okay. And did you make any attempts to reach out to any of the various neighbors about the application and what's being proposed this evening?
So we did to the surrounding 20 neighbors, provided a cover letter and a brochure detailing, the date of zoning that we were requesting relief to construct a home. There were 2 different letters that went out. The first home that we were originally going to pursue ended up actually being a little bit larger from a building coverage standpoint. So instead of adding that variance to our application, we did a redesign on a home that we have constructed previously. On Monday, we resent that notice out to the neighbors so that they could have that particular brochure. On the cover letter, it asked that if anybody had any comments, concerns about the particular design or style of the house, that they could reach out to us via email or phone. We did not hear from any of the neighbors.
And that's all the questions I have for Mr. Alexakis.
No, I can't understand this. Okay, how did you learn about this tax lot?
I don't know what you mean by tax lot. How did I learn about the lot in general? The lot was
Yes.
posted on the MLS.
Do you know what the difference is between a tax lot and a zoning lot?
And this is based on the testimony.
Yes, but they keep calling it a building lot. There's a difference in the county of Delaware and the township of Newtown between a tax lot and a building lot. Many people here right now have more, their houses are going to get 2 or 3 tax bills. But that does not mean that each one of those is a buildable lot. If they are all on one deed, they therefore are only tax parcels. They are not building lots.
We're here for his variances. On this lot, though, rather than going into this whole thing with all of the.
Okay.
I know we've gone down this road before on other properties, so I just want to try to keep this in line.
When you originally looked at this property, were all three tax lots part of the same property and used as one property prior to you purchasing this lot?
I am unaware of that information.
Okay.
I do not know what the prior use was or how that was handled from a previous owner.
Mr. Alexack, I may not have asked you this, but I believe this particular lot is it separated from any of the other lots, demarked in a certain way?
There is, on the site plan, if you look to the house to the right, there is a chain link fence along the property boundary. The back left corner, there's also another chain link fence. And then there's a tree/shrub line between the houses up front and this particular building lot.
And to the best of your knowledge, has this particular lot that you purchased, and there's the deed is marked in the package as Exhibit A3, has that been held in single and separate ownership?
Yes,
It was prior to you purchasing it, or are you saying it is now?
it is now. Again, I don't know what the parcel was previously. You know, we don't pull the deeds from, you know, surrounding homeowners to see what these lots are.
Okay.
But as far as you know, there are no improvements on this lot that were associated by any other prior ownership of any surrounding lots. Is that correct?
No, when we looked at the lot originally, being that it was fenced on multiple sides, it delineated the boundary of the particular lot. Let us know that the neighbors knew that this lot was in, you know, sole and separate ownership from them. So from our standpoint, you know, this was a legal building lot when we purchased.
Did you ask the prior owner if the lot had been legally subdivided?
No,
How much did you pay for this property?
Objection.
From the
Not
paper?
relevant from a zoning consideration.
Okay. What is the estimate of the cost to build a house on this property?
Objection again. It's not a proper zoning consideration. And your cross-examination is supposed to be limited to my direct, what I asked this particular.
Which is what I
witness.
keep saying.
Well,
I keep
you
telling you,
know,
based on the
between the
testimony.
microphone and the mask and everything like that, I didn't hear every
Okay.
answer he had. Okay, so. Okay, have you marketed a similar house for a property you own in Florida Park?
Again, it's
Yeah,
not, it's
I
not,
agree.
Okay, so then. I'll give you my exhibits when it's my turn.
Can I ask a question?
Yeah, please, again, if it's regarding the testimony that he gave.
Yeah, he said he sent out 2 notes to the neighbors within the last week or so. There've been 2 revisions done in the last week or so. So this rendering we're looking at today, that's very deceptive. And the fact that it doesn't show the neighboring properties, how many more times will you guys be redesigning the property or the home relative to this variance?
So when we submit a property, again, we discussed why there was a revision to the property. One, because the other one was larger in building coverage. So in lieu of requesting the board for additional relief and constructing a higher percentage of the building coverage than what is allowable, we did a redesign to make sure that our minimum relief was being requested. The home that is presented tonight is the home we would like to build.
Can you tell us in good faith that that redesign is an attempt to satisfy the property, or are you doing that to act like you're sacrificing so that the board thinks you're trying to comply with what you
I mean,
have
I don't want to speculate what the board is going to assume or think.
I'm
You
just
know,
asking you.
From a zoning aspect, generally speaking, in any zoning application we do, they want us to come in with the bare minimum relief necessary. So we were able to design a home that could meet the building coverage, cannot meet side yard setbacks under any circumstance. There's no habitable residence that can be designed or built on this parcel that does not need side yard relief.
I guess if I could rephrase my question, you've had the property for multiple months, you've had that design. Why in the week leading up to today did you decide to change that?
It was through attorney review. We had submitted the application, you know, multiple facets or individuals looking at it, including, you know, our engineer. It was simply just missed that we were over on building coverage. It was brought up the Friday before the Monday, and that's when we chose to pivot to an alternate design that would meet our building coverage. You know, and at the end of the day, the new house is a significantly smaller home than what I was proposing. You know, the previous design was a 4-bedroom, 3.5 bath. This is a 3-bedroom, 2.5 bath. You know, we did that because we wanted to come in good faith, saying, you know, we're requesting the smallest and lowest variance possible.
Last question, please. What's the difference in square footage from the last proposed building structure to what's been proposed now?
So I don't have the review. Here it is. There you go.
I think you're at
Roughly,
1900 square feet now.
the previous house was roughly 2,700 feet.
You're about 800 square feet less.
Yeah.
Gregory Scott. The packet that you sent out with the plot plan, I can't really see your general notes. Do you have a larger copy that I may have, please?
Our engineer in the back actually has one.
D size? Or
So he's
something
got
bigger?
a full phone
Do you have
board.
it on here? Because it's shown on your drawing and it's not shown on there either, so.
He actually, if you want to just, you can head to the back. He actually has all the notations on there.
I have one more.
Yeah, that's a good question. Is what we're looking at here the latest?
Yes.
So I also don't see the telephone pole that's out there. What's the plan for that?
The Pico pole.
There's a light pole, like right in front of that property. What are you doing?
So right now, our driveway passes that light pole. When we go in for our Pico application, Pico will make a determination on whether they want to relocate that particular pole. It's inside their right of way, so we don't have a determination on how they handle that.
The difference between the first house and the second house that you gave us in the mail is the difference in the square footage and that you took off the third floor. Because the original plans had a 3-floor.
They were
And now
both,
it's a 2-floor home.
both plans were designed as 2.5-story homes, which is allowable under the ordinance, not to exceed 35 feet of average grade. We did eliminate 545 square feet, which was the bedroom, bathroom, and play area.
On the third floor.
You know, that's a portion of that. And then 250 square feet per floor, 500 feet was eliminated because we shrunk the house from 50 feet, more than 500 feet from 50 feet to roughly 38 and a half.
How high is the house, the second house now?
They're both designed to be under 35 feet of average grade, which is per the ordinance.
What was 37 feet? You mentioned something earlier, 38 or something.
Depth of house. Yeah, the depth of house previously was designed at 50 feet. We pulled the house down to roughly 38 and a half feet to meet the building coverage.
Okay.
It's slightly off from that number, but you know.
Okay.
Were we looking at what was posted online? We got notice of the new plans or old?
So
That's the new plan.
that's the new, but both of them are included in the package as the exhibits.
Attached, I believe these are the new plans
They are.
that you have tonight.
You can see where it says the 25-foot rear yard on this particular plan goes to the rear patio. Previously, the rear yard, 30 or 35, whatever it is. Previously, the building envelope or our house went directly to that line. And then the patio, you know, slash deck was in our actual rear yard. We since put everything forward to meet that building coverage. We were roughly 275 square feet or therein.
Again,
over the
from a
building
timing
coverage.
perspective, we were given notice of the application, I don't know, a week or so ago, 2 weeks ago, and reviewed this. You said you sent out the letter on Monday, as in 3 days ago?
Well, we sent out our redesign on Monday to the neighbors.
Okay, but the township had the redesign that they
Yeah.
submitted in here
Yes,
prior to that?
I sent it, I picked up on it. Was it last Friday?
Well, I had surgery
It's
on
like
Friday. so
Friday, I
Probably
think.
Thursday.
And I believe I sent an email to Andy and then,
Information we received,
Yeah.
it's date stamped, the new information is date stamped today.
it was December 13th, I believe is the latest. 8. And that's Exhibit A8. So the,
This gentleman has some questions here. Give your name.
sorry to read the
Alex Pondock with 203rd Avenue. Pondock. Okay. I noticed that the property line for the new home is 7.5 feet, correct?
Side yard.
Side yard, right. And from my property line, it is 6.5.
7.5 from my house to the property line is 7.5 feet from both.
Right, but for me, what is the township rule between the two properties that they have to have that variance?
Traditionally speaking, they take into consideration neighboring properties and, how those properties are to be impacted. However, what they would be looking at is, safe access at 7.5 feet. Generally speaking, for these type of applications, if this was a smaller lot, side yards can go all the way down to 3 feet on any particular property and still allow maintenance and access around the particular dwelling.
Thank you.
Where are you? I'm
Where-
sorry?
yeah, where-
6.5 feet? What are we looking at? Where are you versus the 7.5?
I am at where, I'm sorry, I don't have my glasses, but to the right here.
Yeah.
Yes.
Okay.
From that property line, if I could, please.
Close to the property line, not.
What's your last name? Pondock. Okay. The dwelling, I'm 6.5. I did the measurement. Took a tape measure. There was a metal fence. I got 6.5 feet.
So that is
Right,
your
you're
house.
6.5,
This is
but
my
he's,
house.
he's 7.5 off of the property line. It's
So is
fine.
that a potential fire issue if there's a fire in one of these houses?
I don't want to
For either?
start, I don't want to start
He's-
going down this path, but
I mean,
again,
it's
a
an
fair
issue,
question,
it's a
and it's,
question, Right?
Andy, is it 15 feet is?
I can answer, first of all, this house will have to be sprinkled. That's one issue that we try to resolve by our chapter 88 ordinance. House will have to be sprinkled.
His is 6.5 and he's proposing
It's
7.5,
still 7.5. He's just close to the property line.
closer than he is.
Yeah,
We also sent a letter and requesting.
interesting.
Yeah, I know.
So.
If I can for just a second, if you are going to speak, please step up to the mic so that we can make sure that everybody hears. And Andy, I think your mic is off, so.
Where's your HVAC unit going? On the side? Would that restrict access along the sideways?
So.
Going in the back or?
We haven't laid out the mechanicals for the particular property.
Okay.
Typically in a 7.5 foot side yard, they can be placed on either the left or the right side yard. They don't protrude enough from the building to impact, maintaining of the property, getting around the property or any of those things. If the board does recall, on a previous application, we did have a side yard of 5 feet and 7.5 feet. We had asked on that application for that to be reviewed by the fire marshal and make sure that it had access or safe access for emergency personnel. He had agreed at that time for that particular parcel that it did. We also did send this particular plan in for review if he had any objections or safety concerns that he could comment.
That is something that I do remember a similar case where this was an issue and we got the opinion of the fire department. I think it was, I forget if it was the fire chief or the actual township fire marshal. And that worked out to be favorable to the applicant at the time. Totally different application, but similar type circumstances. I don't know if there was a fence in the last application or not, but yeah, I do recall that.
Where's your construction entrance to the site?
Directly off, we're required 20 feet at the base of our driveway.
Do you have an erosion and sediment control plan?
So
I feel like we're doing the same thing again, though, where we're starting to go.
Okay, I could
Off-
ask this
off
question
testing.
later, though. Is that okay?
Well, it's the engineer is actually going to address all of
If he
these.
references
All
that,
right,
then
I'll
you
wait.
can cross-examine
Thank
him.
you.
That's fine. So do you have, are you,
I'm done with Mr. Alexakis if you guys are.
Sakura?
Yeah, I mean, just, the engineer's gonna handle this as well, but since you're the construction guy.
That's what they say.
So just, we have, if the board decides to grant this, we have other non-conforming lots throughout the town. Lots, they're very difficult to construct on. What is the plan to continue construction? lot. So that
Yeah. Yep, so we actually construct on lots smaller than this. We've also constructed on similar sized lots in the Newtown Heights neighborhood. Two things. So we'll be hauling dirt off site, staging it and bringing it back, right? Which allows access directly around the building, prior to backfill. Secondary aspect of that, everything comes in stages. So as opposed to, let's say on a flat half acre on another parcel where I'm delivering trusses, full house packs, multiple different sub grooves, petty bones and all of those things. This house will actually be phased, first floor deck, first floor walls, second floor deck. And there's more than enough room in the front of that, when we stage smaller deliveries that are coming on. We also, again, on larger homes, we may have, 4 or 5 tradesmen in there at one time, mechanical, electrical, sprinkler. On a house like this, we bring them in one at a time to try to alleviate any undue burden for vehicles that may be coming through the property.
Would you agree to those measures that you just stated as conditions of the variance?
Absolutely. In building in these neighborhoods before, neighbors are passionate. We want to, understand that change is happening and coming on some of these non-conforming lots, be sensitive to that fact. But I'm going to be here for 6 to 9 months. I want to be able to get along with everybody. I want to build the next lot in Newtown Square and other municipalities. And we do that by trying to be favorable to everybody that's involved.
Thank you, that's all.
Any other questions for this witness regarding his testimony?
Hi, my name's Robert Stidham. I live at 308 4th Avenue. You said that you built 25 houses last year, or 20? How many of those needed variances?
Objection to the relevance.
What's that?
Objection to the relevance.
Why? He said he built 20 houses. Did he have variances on all of them, or?
It's not relevant to what we're before this board to rule on. It's not
Agreed.
proper zoning
I
consideration.
keep saying, let's just keep the questions based on the testimony that he's giving.
Well, he said he built 20 houses.
That's it.
So
You want to
were
ask
they
him if he
all
built
legal?
21 or 19?
Right? Where do you live at?
Why does that matter?
I just
Well,
want
if you're going to get up here and just ask irrelevant
No, I'm saying
questions,
you asked me where I live. Where do you live?
I didn't, you have to do that for the record. Is this really happening?
Anyway, I just don't think you should build a 3-story house on a 40-foot lot. Thanks.
You mentioned that you're going to take the dirt off and bring it back. Do you have a copy of your erosion and sediment control plan?
So you don't proceed, it's fine, I can answer the question. You do not proceed through the engineering process of erosion and sedimentation control prior to zoning. Okay, what happens is we come in and we present a zoning application before the board. Should this application be granted, we then have to comply with all aspects of developing of the property. So, stormwater management design, erosion and sedimentation control, phase 1, if applicable, for the parcel. All of that is reviewed by the township engineer, which is a third-party firm hired, to manage those applications. It's a lengthy review process. It will be several revisions that go through. We are then given a construction sequence as part of our application. Once Stantec says, hey, this meets everything from a design standpoint, we then file for our building permit. But the zoning application is the first step in what is a lengthy process. If I can't meet all aspects of erosion and sedimentation control, this project cannot be built. Okay, stormwater management, flow of water, all of those things. There's no reason for us to think that we cannot comply with those things. But, the zoning application, as costly as it is, should the application be denied and cause a domino effect through change or alteration, let's say, you get the zoning approval first, you then follow through with your design and permitting process.
So what if you have to change aspects of your design, will you then modify your plot plan and send it out to the group? How does that work?
So we don't send the plot plan out to the surrounding neighbors. It is public information. It is submitted to the township. You can go into the township and review building permit plans, plot plans, things of that nature. If there is a significant alteration to what we are proposing, through design, we would have to come back in front of the zoning hearing board, represent our application for the changes that we've made, and kind of start the process all over. So, we try to check all of the boxes, building coverage, impervious coverage, all of those things, just to have the 7.5 foot side yards. We have a pretty good idea on what we can get approved, in each step through the process.
Okay, thank you.
Thank you.
I just, is it, the plans?
Can you step up to the podium because we have to get you,
I just want to ask, the plans don't.
I know we have to get it on the microphone, so.
The plans don't show it. Is there going to be a basement in this property?
There is a basement.
Okay, because there was,
It's partially below grade. It's not 10 feet below grade, no.
okay, but on the two sets of plans that you delivered to my mailbox, neither one had a basement.
So we typically just show, first, second, third floor, their brochure plans.
Okay, well, no, I just wanted to know if you planned on having a basement.
All right. I'll call your next
Okay,
witness.
our next witness is Nick Vistardis.
I do.
And with whom are you employed and in what capacity?
West Stars Consulting Engineers, I'm the president.
Mr. Vistardis was previously accepted by this board as an expert. His CV is marked in your package as Exhibit A8. He's happy to provide his qualifications again, but I know you accepted him. I wouldn't say it was about less than a year ago.
He's accepted.
Thank you.
Question, expert on what?
Expert in the field of civil engineering. Mr. Vistardis, are you familiar with the property, its features, what's being proposed, as well as the surrounding area?
Yes,
And you're also familiar with the applicable requirements of the Newtown Township zoning ordinance, is that correct?
correct.
And do you agree with Mr. Alexaki's description of the unique characteristics of the property?
Yes, it's a narrow lot, non-conforming lot area and lot width.
And did,
We can't hear you.
up a little bit? We can't hear
There's a microphone right there. If you turn that on, just put it right in front of you.
and those conditions, were they long and narrow lot and the limited lot frontage, correct?
Correct.
And your office prepared, and I feel like we might be a little redundant because I know Ryan actually answered a lot of these questions during the course of his testimony, but your office had prepared the first exhibit plan, a zoning plan that was submitted with the application. That's correct?
That's correct.
And then you prepared an updated plan and you heard Brian explain that it was because it was caught that the building coverage exceeded the amount and therefore it was updated in order to make the plan compliant with the building coverage, correct?
Correct.
So the plan that is being proposed is the one that is in the package referenced as the updated zoning exhibit plan with the last revision date of December 13th, 2021, correct?
That's correct.
Okay. Now referring to that exhibit, could you describe again what's being proposed for the property and the dimensional variance that's being requested?
Sure. They're proposing a 25-foot wide house, roughly 38 feet long, about 960 square feet. The house and all the impervious will meet all bulk zoning requirements. The only thing we're asking for relief is the side yards down to 7.5 feet.
And the application at the appropriate time, as Ryan mentioned, will also meet all other applicable stormwater management, erosion sedimentation controls and all that should this board grant this application, correct?
That's correct.
Now, I'm referring to the existing conditions plan, which is marked as Exhibit A5. Does that plan depict what the minimum size house would have to be should the plan comply with today's ordinance?
Yeah, it would be a 5-foot wide house.
And obviously that would be impossible to construct, I assume.
Correct.
And the plan will also be compliant with the maximum building coverage, the maximum building height, correct?
That's correct.
And are you familiar with the applicable standards for variances as well as are set forth in the Newtown zoning ordinance with respect to the grant of a variance?
Yes,
And I believe you already testified that in your opinion, there were unique conditions of the property which necessitated a hardship. Is that correct?
that's correct.
And given the fact that the existing condition plan shows that you can only build a 5-foot wide house, would you agree that the property cannot be developed in strict conformance with the zoning ordinance?
Yes, I agree.
And in your opinion, was a hardship created by the applicant?
No, it's an existing non-conforming lot.
And in your opinion, would the requested variances alter the essential character of the neighborhood or impact the surrounding area?
No, I believe the home would actually fit in. There's a wide variety of house styles there. And this one kind of fits in right with what's next door, actually.
Did you prepare Exhibit A9, which is a tax map showing the surrounding areas?
I did, yes.
I feel like some of mine, I don't know if yours are out of, some of my exhibits may be out of. Okay, and could you explain for the board what that exhibit? Okay, I apologize. Could you explain what that exhibit shows?
So the orange is the lot we're talking about. Everything I outlined in green is an existing non-conforming lot, either width-wise or area-wise. So you can see it's almost probably half of the lots in here are that way.
And given the fact that the application complies with all the other applicable area and bulk requirements other than the setback, which is necessitated by the existing minimum lot width, would you agree that what the applicant is proposing is the minimum variance relief necessary and the least modification under the zoning ordinance?
Yes, it is.
That's all the questions I have.
Mr. Score, any?
Well, I just, when you say it's the minimum required setbacks necessary, you're saying for a 25-foot wide house, right?
Correct.
I mean, you're not testifying as to whether the house has to be 25 feet or anything like that.
Well, I know there is applicable case law, which the Commonwealth Court has said that the 25-foot wide house is the minimum reasonable house. Sure.
That's so he's not answering that. You're just citing case law.
Yes.
Okay.
Yeah, what's the case?
The case is, I can give you the citation. I can read it. It's Borough Emmanuel v. Schuler, 409 Atlantic 2nd, 444.
Remember, you have to be at the podium and you have to have a question when you're asked. So the chairman will come up and invite people to the podium. You cannot yell from the audience and ask questions without audio and being invited to the podium.
Could you repeat that?
Things like that.
Sir.
We need to be conforming to rules. Thank you.
The citation again was 409 Atlantic 2nd, 444, and it was Borough Emmanuel versus Schuler, Schuler. Yeah, Emmaus. I apologize.
Borough what? Emmaus? was
Oh,
it?
of Emmaus.
Oh, Borough of Emmaus. Okay, thank you.
Wow.
Sure, Elizabeth Scott. This drawing or rendering is misleading. It shows it as one parcel, and that's actually not how it is. It's split into.
But he owns both?
That wouldn't be the building lot. The tax lot that's actually split. So it might be under one deed right now, but it's.
Do you mind just going up and
Sure,
pointing
sure,
to
sure.
how?
So what they're proposing is to build on this part. Like right here. This is owned by, this might be one owner right now, but they're saying they want to build on this lot right here.
No, it's incorrect.
It's the entire lot. There's no split.
There's a home all the way down.
You have to be at the microphone. We have to-
There's a home on Fourth Avenue that backs up to it.
There's a property line between those.
The area in red is what we're discussing.
Correct.
And the area in red is owned by the applicant?
That's
The
correct.
entire area?
That's correct.
But the
Shown
main
on
thing we're here to
existing
discuss
conditions
is
plan.
the side yard setbacks.
Yes.
I don't want to go down the path where we're dealing with.
I'm
how
talking
things
about
are
the
deeded.
rendering though, because that's relevant, so I didn't
Okay,
want to
that's fair, you're
forget
right.
about it and then, but I don't.
Ms.
think
Scott,
it-
but just to clarify, I think Ms. Ricchio has it in item 4, of the applicant's packet. The aerial view shows that 203 Fourth Avenue is, if you look to the northeast, there is a property there, but the area in red does look correct.
Right. But the pin
Yeah,
is not what we're talking about.
Yeah, so the pin.
South of the pin.
the pin
Oh,
is
okay,
shaded in green.
okay,
Yeah. So
got you, okay,
this particular property doesn't have an address yet.
okay, sorry, it was
Right.
flipped for me. Okay, sorry, it was like flipped for me, sorry about that.
Sue Cordes, 147 Third Avenue. The house that you're looking at, that looks like it's 2 with a driveway. That landowner owned all the property from there to Alex's house, which is 6 feet from the next house. So he had lots that he sold one of his lots on his property. If we can go back to that one where it's highlighted okay. So Alex's property is to the right of the colored in area. Then he purchased the colored in area. That next lot belongs to the following lot. So it looks like these are all homes, but they're not, they're just lots. If you scroll that up a little bit, so I can show, no, the other way, okay. So across the street from Alex's, it looks like there's 1, 2, 3, 4, 5 homes, when there's only 3. There's one at the corner, and then there's O'Brien's, and then DeCecco owns 2 lots, and then we have one at the corner. So when you're looking at this plot plan, it's a little confusing because you think that we're talking about homes. We're not talking about homes, we're talking about lots. And as Ms. Ricchio said, these are deeded separately. Why they were deeded and why they stayed that way, I have no idea. But these are not homes. If you drive in our neighborhood, these are not homes. There are very few homes in this area. Now, by putting this home in there, the guy that sold the property to this gentleman, he kept a buffer for himself. But Alex, who just moved in this year and thought he had an area to look out on, now is going to have a 2-story home right in his backyard. And we, the neighbors, are thinking that it's just too close. So I really wanted to show you the plot plan because those are the ones that I can identify. I'm sure people here can get up and tell you how many lots they own for one property.
Which house is Alex on here that we're?
Alex is to the right.
Right there, okay.
Okay, and then,
That's where the property line was,
And that's
6.5.
Yeah,
Thank you.
Right.
Right.
is that a fair representation of Alex's
Lot.
lot size? Of where there is Alex's house?
yeah,
We just talk about some context, and Andy, maybe you can chime in here. Historical context for why we have these non-standard lots in Newtown Township. This is a common issue. We have older neighborhoods now. We have the Heights, we have Florida Park, we have the Avenues. This is a recurring issue, obviously, clearly, right? The conflict that we have as a board and as a township is that, by law, property owners have the right to full use and enjoyment of their property. What the applicant is making the case for, and I'm not trying to make your case for you, I'm not getting paid for this, but is that the hardship was the original layout of the zoning map, right? With these older neighborhoods. So if you could kind of give some historical context on why that happened, maybe, and specifically with these neighborhoods, which, by the way, I'm a neighbor, so not for this neighborhood, but for others.
I have the complete history, but.
And we need.
I'm directing a question towards our zoning officer, because this is a trend in the township. We're sensitive to it because these are the older neighborhoods that have non-conforming lots.
No, but I also heard you ask previous applicants, have you gotten approval from your neighbors? And they certainly have enough land between their properties. We had one that just needed one for a roof. He had a lot of ground between he and his neighbors. We're talking about 13 feet.
Of course, absolutely.
So, I think you need to take that into consideration. Quality of life means a lot. And, we live in Newtown Township for a reason. So, but I really did want to make the distinction that on this street, there are an awful lot. On the other side of the street, I can tell you that two of them are combined again, so as I said, I'm sure that all the neighbors can get up and say, I own this lot and this lot. So that's really not a good description of the neighborhood. That's plots. And you want to get away from plots and call it deeds. But, they brought this up. I didn't.
Do we have anyone else that wants to cross-examine this witness?
Any other questions for Mr. Lestardis? No, okay, we just have one last with the architect. Pretty brief. Didn't fall asleep back there, did he?
Swear the testimony given will be the truth. The whole truth.
Yes.
Thank you.
Could you state your name and address for the record, please?
Richard Cavada, 311 North Darlington Street, West Chester, PA. I'm the owner of RHC Design Architect for the project.
You spell it,
Covatta.
And Mr. Cavada has also previously testified and been accepted as an architect before this board. His CV is marked as Exhibit A10, if my number's right, which it may not be. A11, I apologize.
You want him in as an engineering expert, is that what you're saying?
Architect, yeah.
Okay.
And you're familiar with the applicable ordinance in the surrounding area, is that correct?
Yes.
And were you responsible for preparing the architectural rendering marked as Exhibit A12?
Yes.
And does Exhibit A12 accurately depict the general style of the home that the applicant is seeking to build on this property?
Yes.
And in your opinion, is the home consistent generally with the character of the neighborhood?
Yes, it's an eclectic neighborhood. It's a nice neighborhood. It has a lot of different variety of houses, different roof lines, different styles, different widths, different heights. So I feel that it fits in the roof style. You can see that roof style on one of the houses on 4th Street. And there's one other bigger house that's a little bit wider, but it says that same gambrel style roof in the neighborhood.
And do you believe that allowing a building width of 25 feet would alter the essential character of the neighborhood? That's all the questions I have.
Mr. Score, any questions? Oh, sorry.
The only question I have is the rendering, which is that Exhibit 12?
That's correct.
Is that the house that's going to be constructed, that model?
Yes.
And is that a fair, I mean, I understand it doesn't show basements and stuff like that, but is that a fair depiction of the orientation of the garage and front
Yes,
porch?
yes, in that house, the lower level is the garage, and as of now, it's just drawn as unfinished space behind it. There's a basement below it. The front door comes in at the mid-level, and then you go up to the main living space, and then from there to the floor above.
And so I guess what I'm asking, and you might not be the right witness, but would the applicant agree to a condition that this particular, if the board's inclined to make it a condition, this particular house is what would be constructed as opposed to coming in?
Yeah,
and
the applicant would have to say that, but that's what he asked me to design, and that's what I designed.
And my understanding, we can call them up here
Yeah.
to.
I think they'd accept your
Yeah.
representation.
Yes.
Is that correct? They would commit to
Yeah,
this and not
they would.
do a
I mean-
change up so that the,
Exactly. And generally, I mean, there might be tweaks here and there, but generally it's going to
Understand.
have that overall appearance.
okay. Thank you.
This is the latest revised version from Monday.
Correct.
Can you point out what changed visibly? Not as long.
Yeah, depth-wise, I was informed that they wanted to reduce the square footage, the building coverage, so we reduced, pulled it back.
Height's the same.
Height's the same, and, there's definitely a difference in the architecture, gables versus the gambrel. And then, working, now this is a two-story with, living space on the third floor. And this one, we put the third floor in the gambrel, so it's actually 2.5 stories at that point. Just to keep the height down and still get the garage and good living space.
Thank you.
All right.
Just a quick question. Obviously, the garage is lower below the first story, correct?
Correct. Yeah, you come up half a flight into the front door. Once you're in the house, you come up a half a flight to above the garage.
Will there be, the basement is beyond the garage?
Behind the garage, on the same level as the garage,
And
correct?
the approximate height of the basement behind the garage is?
It should be, we usually shoot for 9 feet. It's anywhere between 8 and 9 feet for that finished space. The future optional finished space. Minimum height is 7 feet for living space, and we try to do at least 8, if not 9, as long as we keep in the building height requirements. And we usually try to get a 9-foot first floor and 8-foot second floor.
I know Andy has a question over there.
Yeah, just one thing that I want to make clear, from the site plan, it shows it as a complete rectangle. But from the first floor elevation or first floor plan that was provided as part of the exhibit, there is a bump out on that side, on the, I guess it would be the west side.
Yeah, it's actually the covered porch recesses back in, so
No,
that.
not the covered porch. I'm talking about the
Oh,
fireplace.
the fireplace, yeah, that's a
So-
little bump out for a fireplace. And
Right. So I guess my question is this, does that encroach further into the 7.5 feet being requested?
yes, but it could be removed if it's, but yes, it's there. There are allowed encroachments into the setbacks. Certain things, bay windows, and a certain distance you're allowed. So if,
Into the required setback?
yes, so if you said it's got to go, then it would certainly be able to.
I just wanted to point the fact that there is yet a further encroachment shown on the first floor elevation.
And that's
It's not necessarily depicted on the site plan.
Yeah, I mean, we can pull that entire fireplace into the room, if that pleases the board. It sticks out approximately 18 inches right now. Andy could probably reference what the zoning code is. Many municipalities don't reflect fireplace, dog boxes, or things of that nature. So it's not uncommon that they're not shown on site plans. But if it, helps please the neighbors, and, we can definitely just pull that in. Also, when you're looking at that particular site plan, we could shift the entire house to the left into a 5-foot side yard and a 10-foot side yard, which would give the gentleman on the corner an additional 2.5 feet. If that's something that helps a little bit. Thank you.
All right. Any questions for this witness from any of the party protestants based on the testimony he's given?
How high is this house plan?
From the average grade to the peak of the roof is 35 feet. Maximum building height.
Okay, you mean from the ground level where the driveway is? up?
The finished grade around the house.
Okay.
Nick, it should be.
And is the driveway going to be to the left where the garage is on these plans?
Yes.
Okay, so then the telephone pole would
So
create a
again,
problem.
that's more of a, that's more on Nick, the
Engineer.
engineer. He does the site plan.
Any cross-examination from any of the party protestants? Any other witnesses?
I have no other witnesses. I would just ask that our exhibits be entered into the record.
They are admitted into the record. Any closing arguments then?
Just that I believe, yeah, you can be excused. That the evidence
Thanks for not
supports the
calling.
fact that there is definitely uniqueness to the property itself, given the long and narrow shape of the lot, the nonconformities. The laws recognize that the applicant is permitted to continue lawful nonconformities, and that it is a justification for the hardship to support the variance, and that we believe the testimony supports that what he is seeking is the minimum relief necessary, and also would be agreeable to certain conditions being imposed, as some of them outlined by the township attorney with respect to construction and what he would be agreeable to do. Also, should the board be inclined, as long as we could get that 25-foot width house on the property, I think there would definitely be flexibility in moving it a few feet here or there, if that would be something that would help with one of the neighbors.
Okay, that's, all right. Any closing testimony before we close out the record from any party protestants?
Testimony. I've typed up what I want to say to read it to you because I get very nervous
Understand, take your
and
time.
with COVID, and I always.
Are we making this an exhibit?
No, that's just for him.
Oh, okay.
I have copies for the rest of you after I'm done reading it.
So if you want to offer it as an exhibit, we can mark it, put it into the record as well as your, whatever you're going to say.
I'm just going to read it, okay?
That'd be fine.
Okay. My name is Diane Ricchio, 209 4th Avenue, Newtown Square, Pennsylvania. I want to provide the zoning hearing board with some history of our neighborhood. I was brought home from the hospital in September of 1952 to 210 3rd Avenue, Newtown Square, my parents' home, which they purchased in 1950. Back then, the area was known as Larchmont Square. My parents brought their home on 3rd Avenue, 60-foot wide, and 4 building lots at the time on 4th Avenue, 120-foot wide, but put all of the lots on one deed because at the time, each deed cost $25. So to have everything on separate deeds would have cost $100 more. And as a young family, $100 was a lot of money, as the cost of all the property at the time was $12,000. In 1959, Newtown Township changed its zoning laws, requiring building lots of 12,000 square feet. That is why when you come through the neighborhood, the smaller property homes are for one of 2 reasons. They were built prior to 1959, or they were originally purchased prior to 59 in single and separate ownership. Very important. After 1959, they needed either the 12,000 square feet or a subdivision and variance to build on the property. The tax parcels were originally registered with the county tax office. So depending on how many parcels you owned, you would get a separate tax bill for each parcel. A tax parcel is not a deeded lot. The county explained it would be too expensive and cost too many man-hours to incorporate all the tax lots. So if you got more than one tax bill and you wanted to incorporate them into one, you had to pay for it. Otherwise, you would receive multiple tax bills for however many tax parcels you owned. Many, many people in Newtown Township receive multiple tax bills. But if they are all on one deed, they are one property. Again, a tax parcel is not a deeded lot. The neighborhood was originally mostly summer homes for people from Philadelphia and other surrounding cities. Like many people now have summer homes in the Poconos and the Jersey Shore, with small lots purchased and small summer cottages built on them. When I was a child, quite a few of our neighbors only came in the summer months, and many didn't have indoor plumbing. Many had outhouses on their properties. A good example of this would be 217 4th Avenue, which didn't have any indoor plumbing of any kind until the current house was built on the property in 1975. In 1976, because it was all on one deed, my parents had to get a subdivision and a variance for their property so that my husband and I could build a home on the 4 tax parcels on 4th Avenue. We had our choices of addresses, 209, 211, 213, 215, because they were the original tax lots. We chose 209 4th Avenue. This is why I want to be recognized as an expert on the history and character of our neighborhood and should be recognized as such. Can I be recognized?
I have a tough time.
I lived there for 69 years. I can tell you every person that lived there from
I
1952
don't
on.
think that qualifies,
Yeah,
qualifies you as an expert in the sense that you could testify as an expert. You're testifying from your historical background that you have knowledge of, with those are facts. But you don't have any advanced education or written any books or any certifications or higher education with regard to the particular subject you're discussing.
Lived there for
So
69 years. Okay,
I'm sure that the weight of what you are suggesting and testifying to will be taken into
okay,
consideration by the board.
okay. So as a child, I was a close neighbor of Joe and Mary Gato, the original people when I was born. I think they purchased property in 1950. So I was a close neighbor of theirs, and my husband and I were good neighbors to them, helping each other as neighbors do. They always used all of their property. For years, when I was a kid, all of the neighborhood children would play with their dog Sparky before and after school. Sparky had a dog house, the old-fashioned kind, like you see in the cartoons, that this parcel that we're talking about, he lived there his whole life on that tax parcel because it was the Gato's yard. Joe had a grapevine growing on 203 4th Avenue that extended into his backyard, which is this tax parcel. Joe and Mary were prolific gardeners, and until they got too old to tend to maintain it anymore, Mary died in her mid-90s. Yes. They got too old to tend to maintain it, always had a huge garden that extended into that property. So it was always used as one property. Treating this tax parcel as if it is a lot to build on is wrong, and it would be illegal. This is not a building lot. It is only a tax parcel. And in fact, prior to 1950, and in fact, is part of 203 4th Avenue and has been since its original purchase by the Gatos back prior to 1959. It has never been subdivided, which would have had to have been done, brought to the township for approval. I am questioning how property on one deed became 3 deeds without a subdivision. And this zoning hearing board should be questioning this too. Is it possible that someone is just making up deeds? Because of my personal experience with subdivisions in this neighborhood, I know that in order for the sale to happen legally, a subdivision was required. This developer must or should therefore know that by doing a subdivision, they would create their own hardship and therefore would not be permitted to build. This is just another case of a developer coming into our township to quickly cash in with no care for the character of our neighborhood. Thank you. Yeah, I'm giving it to them too.
thank you.
And then these are my exhibits. This one,
I know, that's a valid question, ma'am.
okay.
These
Any
individual,
more?
Can you,
No, there's exhibit 1 and exhibit 1A.
okay, we're
My
gonna,
first exhibit that I'm passing to you guys is that I went to the open house by Compass Realtor and specifically asked, and the dear sweet lady signed at the bottom that it is 3 lots on 1 deed. Okay, so that's what they were originally selling, 3 lots on 1 deed.
This is for the lot, for the lot itself.
That's for the whole property. If you read, you can read the details. They tell you that you can sell off the back lot. They don't tell you how, and they don't tell you if you do, if you do.
we're gonna mark this as Riccio 1. Riccio, sorry.
Oh, I'm sorry, that's who I wanted to do.
Okay, this is the original.
Okay. And then these are 1, 2, 3, 4, 5. These are all of the neighbors who have signed a petition against this because it is not.
We'll mark this as Riccio 2.
Heard about that 30 years ago.
So I went to the open house. I spoke with Ms. King. She explained that it was 3 tax lots on 1 deed. That, and then she also called, in fact, I don't have my copy. What am I doing with it? I just need to see this for a minute. Can I get it back in a minute? Okay, so I just want to get her name right. Lindsay Good was the actual realtor for Compass. Shannon King was the woman showing the house at the open house. Shannon even called and double checked with Lindsay Good, who said, no, it is all 1 deed. It is just 3 lots, it's 3 parcels. And if you read the description there, it tells you. Then lo and behold, without anyone coming to you, if it's on 1 deed, 3 tax parcels, shouldn't someone have had to come to you, the owner of the home, to have it split? I'm asking that
Oh, I
question.
thought you were doing your closing argument, so
No, I'm just asking a question.
this is just a testimonies. No, not public.
No, it's
comment.
not,
She does
no,
get to give her-
I'm asking you a question.
We're only here, that's the thing that everybody seems to keep forgetting. We are only here to discuss the variance for the side yard setbacks. That's what's in front of us, not how this lot is.
So you're telling me, as a representative of the township,
I'm not saying that. I'm
if
just
it
saying our
was
job is
purchased
to do what's put in
illegally,
front of us, and that's what
it's
we're here for.
still, they're still allowed to do it?
We're not experts in that area. We would have no knowledge of whether it's legal or illegal. We're here for the matter at hand, which is the zoning variance. They're asking for an exception on the setbacks. So understand you have a point. It sounds valid. I don't know that, I don't know the legal ramifications. around
This,
it.
and again, we're trying to, testimony's been closed out. This is your closing argument. Now you're getting to ask some questions.
No,
She's a party.
no, this was, I'm a party protester.
I agree. I'm telling you that you're.
Jurisdiction for subdivision and is with the supervisors.
Yeah.
We're not dealing with a subdivision. There may be 3 lots and it may have been subdivided, or he may have applied for zoning first and needs to go for subdivision after he's granted or denied
Okay,
his zoning.
well, I
So
guess let me, and
that's
you're,
up to the applicant.
you're
to
an
make that
attorney,
choice.
and Mr. Sikora, you're an attorney, okay? Is it legal for me to, I have a property,
We are
on 1
only
deed.
taking things to the zoning variance. We
Right.
can't answer any questions
I-
on property zoning. Is there?
I'm asking,
But
Mrs.
this isn't the
Secor-
time or place. We're only dealing with
Especially not for them to be
the
giving out legal
variance.
advice.
We cannot take an answer time.
so if someone
Our
comes to
board
you,
here is to
okay,
deal with the variance.
but, okay,
That's
so
it.
I'm asking you, if someone
Lots of
comes to you with an
everything you're dealing
illegal
with.
deed,
Can be answered to the question to the township. The board is dealing with the variance. That's all we're going to comment on.
okay,
The variance, your lots, everything else.
What I believe Ms. Riccio is doing is checking the grant of variances for this lot, maintaining it under the zoning code. There's this thing in the law called a merger of lots doctrine, based on the code. It's not a common law principle, it's on zoning codes. And what Ms. Riccio's position is, that this lot, because it was held by one person, okay? So at least there's 3 little lots altogether, because they were held by one person. Because, thanks. And because they were on 1 deed, her position is that the lots merged. So I think what she's doing is lodging her objection to you granting the relief for this individual lot based on that that objection, okay? And I believe that you can take that objection, she can note it, she protected the record, and you can, you know what I mean? You can accept that and say, okay, and I think, you know, she's provided her testimony about that. That's already been admitted, so
Okay,
I'm sure there'll be a response from council, and then we can move.
all right. Now, I would like
You know what I mean?
to,
I just want to make sure the record's protected, that everybody got a shot. to-
Tricia, are you adopting the interpretation from?
Yes.
Mr. Spur?
yes. And then I would like
So
to
your
call,
objection's noted.
okay, and I'd like to call
Just
Alex.
clarify though that that's not necessarily the township's position. He was just summarizing what he believed to be her position.
Right, I mean, we do have a definition of lots. And we do have our own version of the merger of lots doctrine in our code, and I am not the person who interprets that. Mr. Auslander can assist you in interpreting that, should you need to interpret that.
Okay. First, I would like to call Alex. Alex, you got to say your last name for me again. Okay. As my first witness?
Well, he is a designated protestant.
Yeah, but can he also be my witness?
No, you have your
You have your own.
opportunity. Everyone's
Now
separate.
it's his turn.
So if you're,
Oh, all right, well then he
He
knows what he has to
can
say.
speak.
Yeah, what he
based on-
will then. You have to say.
Good evening. Thank you, zoning committee, for allowing me to address my concerns in statement with Z 2021-40. I'd like to state the following, just that the realtor Patrick and Constant G. Mercy offered us lot 3 as well for $75,000. But the thing is that we couldn't build on it. And it was adamant that we were not allowed to do that. I did not counter offer it because obviously it was a bit too high. We just started our mortgage. My wife and I bought the home in June 2021. And I can't do anything to a $75,000 property, so why buy it? I would have loved to have my daughter play with a backyard, but again, the price is too high. But I found out that Craft Boutique Home Builders bought the third lot for $50,000 and are building 2 to 3 story home that will be 7.5 feet from my wife and I's property line. That doesn't seem right. And I didn't know that it would be subdivided and be used for building homes. I work from home and I don't need to hear the construction. My daughter plays on our yard and doesn't need to be in danger of the construction. So thank you, and that is my statement. The realtor of Patrick and Constance G. Morrissey. Morrissey.
Ask who was selling the lot today? No. But who sold it to? Property was subdivided from another property on the. Who owned it previously?
Patrick and
Joseph Gato.
Joseph Gato.
Okay. And the realtor told you you couldn't build on it? Like you said?
That is correct.
Thank you. Thanks. Any additional closing arguments from the party protestants?
I'd like to make one comment.
Sure.
Ray Massey, 203 Fort Ave. Couple things here. It seems the board specifically is very fixated on the fact that this is a relief for the side setbacks. And I think it's important to note it's not just the side setbacks, it's the left setback, the right setback, the two of them combined. The 25 by 38.5 foot house exceeds the 20% building area that's allowed. That hasn't been addressed. And additionally, it says the minimum contiguous lot area shall consist of not less than 6,000 square feet, and the lot is 4,800 square feet. So I'm having a hard time understanding how there was a hardship here when the builder knew prior to the purchase of the home it was a non-buildable lot.
Your microphone on.
No such thing as a non-buildable lot. The neighbors keep referencing that, right? It's a legally created parcel. Okay. Alex Aggie,
Legally created.
legally
parcel.
created parcel.
And I want to call attention to a comment that Mr. Lynch made about this being a topic of contingency. It's repeated in this neighborhood. I think it's also worth noting that, this zoning is for special exceptions to the rule. This is a rectangular lot. You knew that prior to the purchase. And variance relief should be an exception, not the rule. And it seems like the neighborhood's trending in the direction of making it the rule, not an exception. I know for me, Diane's been here for 69 years. I've been in Marple Township for 29 years. I lived at home as a grown adult when a lot of my friends were moved down, things of that nature, and impacted my pride a little bit that I lived at home with my parents. And that was to save for a long time to live in a neighborhood like Newtown Square. And I bought the lot and home on 203 4th Avenue with the expectation that I have some privacy in the yard and I wouldn't have a house on top of mine with light pollution, noise pollution, lack of privacy and things of that nature. So I think it's important you take those things into consideration as well when you're viewing this here, because the relief that he's asking for, I think he knew the risk involved with purchasing this property ahead of time. And I think the grant of relief would be a shame to the neighborhood and a disservice really.
Thank you.
Elizabeth Scott. I've actually lived on 3rd Avenue for my whole life, so 38 years. I lived with my parents down the street in the 400 block and then bought a house in the 200 block with my husband when he was deploying to Iraq with the military. So I've seen 3rd Avenue change a lot. And some of it's been great and some of it's been a little confusing. Why certain things are let go and other things are passed through are confusing to a lot of the homeowners. But one thing, we are a bonded community and we are all opposed to this because we feel as though Newtown Square is shrinking as it is. And if you're squeezing homes and homes and homes in, even, it takes away the appeal. Like, I can't see myself living in a neighborhood where I feel like I have a row home right across the street from me just plopped there. So I just think it's ridiculous to take away the green spaces that we have left in Newtown Square. So, thank you.
Thank you.
There's one more thing that I did forget to say, and that is,
If I may just ask, is there any fact that you intended to elicit from any of the witnesses that they did not cover already?
no. This, you just asked me, see, that's why I need to have stuff written down. If you look on the site plans for our community, the Larchmont Square, you will see that there is a lot of 40-foot lots on the corners, like on 3rd and Gilbert, which is Alex's. Across the street from that, they even have a 60-foot lot, but it's still, there's a lot of, on the corner lots, they were sold in these small parcels of only 40 feet. When those people came in to get permission to build from the zoning hearing board, which they were grandfathered in because of they were single separate ownership, they were still given by the zoning hearing board the rule that they had to be single story. And you can drive through the whole neighborhood and see every 40-foot corner lot is a single story little bungalow. In other words, a house that fits the lot. So I wanted you to take that in consideration too, that has been the past zoning board's ruling, and they were always on corner lots where, they could face Gilbert Street as opposed to facing 3rd, but their address is still 3rd and things like that. They're all little houses. So I want you to take that into consideration too, that if you do grant this, you do not have to grant what they're asking for. Thank you.
Thank you.
Hey, I just real quick wanted to say, I lived in the house that Alex lives in. My name is Neil Doherty. Yeah, I still live in Newtown Square because I love Newtown Square. And I can tell you, I looked out the windows he's looking out, and anything going in that property would just be an absolute encroachment and an inconvenience to him in his home. And it just does not belong there. If people want to live that close together, they can live in Lissitor. They can go buy in Lissitor. The avenues are as they are, and they just should remain that way. Thank you.
Public comment, I assume.
Yeah.
If they're done, respond to
Yeah.
legal.
Is everybody done? Just so we can, and we also have another case after this, so.
One thing I just want to point out. I don't have the site in front of me, but I'm happy to provide it to you or the township. But the fact that somebody purchases a property knowing that they need variance relief is not evident that you're self-creating your hardship. There are specific cases that have dealt with that. So the fact that he may have known when he bought this that he was going to need variance relief, that doesn't mean that he created his hardship. I'm happy to provide you with those cases. Second, the lots were previously lawfully subdivided years ago. Nothing recent was done, obviously, as indicated by the tax map, which has them assigned separate parcels and as designated as separate lots. The fact that a deed may have a few lots or parcels, that doesn't mean anything. I mean, you can have a deed with as many parcels or lots on it. That doesn't mean that it's one lot or it's however it's designated, whether usually by a separate parcel number means it's a separate lot. We don't believe that the merger doctrine applies here, that there is a merger doctrine as the township attorney mentioned to you. It's very specific. It doesn't apply unless your ordinance is referenced in your ordinance. Your particular ordinance requires, in order for the merger doctrine to apply, that you actually have improvements that are straddling both of the lots and that you're using it in common usage. So if you have a garage that's on, if you have part of your house, we heard some testimony from somebody earlier the night on another application that was essentially, buttoned right up to somebody else's or may have been encroaching on somebody else's property. So that's not the situation here. This lot was always kept separate. There's a fence demarking it separately from the other lots that previously were owned by the owner prior to my client taking ownership of it. So we don't believe that the merger doctrine is applicable. The law is pretty clear on nonconformity, that the applicant has a right to maintain the nonconforming status and can build something as long as it's reasonable and they're seeking the minimum relief necessary.
All right, thank you.
Thank you.
I have a question regarding case law you cited that referenced the 25-foot inhabitable space or 25-foot width, right?
Yep.
What's the size of the lot and what is the what is it, a one-story house, two-story houses? We're talking about the width. I'm not familiar with the case
Yeah.
law, but
It actually, I think, I'm going to say the lot was actually smaller than this one, to be honest. I don't know if I have, do you happen to have that case, Ronnie?
that's the Commonwealth Court or Supreme?
It was a Commonwealth Court, yeah.
And the court said that was too small.
Okay.
25 feet was the smallest
Okay.
amount.
I believe 5-foot side yard.
It was a 5-foot side yard. Yeah, we think it was a 5-foot side yard. And in that particular situation, the township was saying that they should have built a smaller 16-foot wide house. And the court said, no, that's too small. The 25-foot is the minimum reasonable size house. And I'm happy to provide a copy of that.
I don't think that.
Can we open the testimony back up?
Every case is a little different, right?
Sure, that's why I just want to put everything apples to apples.
There's other facts in that case, so it's not just per se rule that said, hey, 26 is 25 or whatever it is, the minimum that was.
Right.
But the Commonwealth Court in that case, size lot that was sloping, has stormwater problems, this construction was going to improve those stormwater problems. Said that, if you took the lot itself and applied the standard setbacks, it would only be a 16-foot wide house. They said that wasn't reasonable. They said under the circumstances of this case and the circumstances of that neighborhood, 26, I think it said 26 feet actually was
I
reasonable.
think it was a little more.
And it had similar setbacks to what we're talking about here. I don't see them right now. But again, it's precedential to the extent of what the standard is, that it's the reasonable, that it's the least variance necessary, right? That's applicable. In this particular case, that was right. I'm not disagreeing that those were the dimensions in the case. I don't want the board to misinterpret that as saying there's a case in the world that says by definition, you have to allow a 26-foot house in any circumstance.
That's why I kind of wanted to clarify, because the way you presented that particular case law in the context that it was given almost made it seem like, all right, well, 25 feet. It might
Like
not
for
been-
instance, if this
might
was a
not been
20
what you
if this was a
intended, but-
26-foot lot, you can't have. or
That's what I mean.
You can't have a
Right,
26-foot
right,
wide
yeah.
house.
That's
right?
what I wanted to clarify. And then
Right.
the question for Mr. Pondock, is there any building, whether it's a single story, more narrow dimensions, that would be suitable, in your opinion? I'm not asking the applicant, I'm asking you.
5 and 7 foot side yards. What was this one?
No, obviously, because of how close it is. And at the same time, my neighbors already, I can hear them. I can hear them drive in. I can hear them with the garage. I don't need somebody who's 14 feet away from me and I will hear everything. My child is sleeping. Luckily Laura and I got a good child that sleeps, but I don't need a house that is 14 feet away from me and taking away the value of my property.
I think in that case, it was a 40-foot lot width and a 26-foot house. So it
Still
was,
on that.
yeah, so just, yeah.
It looked like it was 5-foot setback on one side and 7-foot setback on the other.
I got it. I wanted to show you I could read.
All right, so we are going to close out the record and the board will make a decision at our meeting January 20th. I'm sorry, public comment. Well, there were people jumping in with public comment before that, so.
Oh, okay.
Oh, go ahead. They were just saying there was other people that got up to talk,
Well, they were all party protestants.
not this guy.
I did not realize that. I thought he was a party protestant.
Used to live there. That's fine.
Patty Wilson, 4111 Battles Lane. Our zoning code does in fact define single and separate ownership. Our lots merge when 2 or more lots have been in the same ownership. That's the case here. And though there has been some interpretation or supposed interpretation that something needed to be on it, there is case law, West Goshen v. Crater, which also speaks to the issue of when you have 3 lots, regardless of a merger of lots ordinance, which we do not have, but we have a very clear ordinance that says when 2 or more lots, and in this case, 203 Fourth had 3 lots owned by the same people, never legally subdivided, 3 tax parcels, they merged according to our ordinance because they were used as one property. I'm going to urge you to take a look at both West Goshen v. Crater and DeChico v. Philadelphia, which speaks to tax lots are not zoning parcels. This is not a zoning lot. Somewhere along the line, somebody made their own deed that said the Gatos somehow subdivided this. In the past, when somebody had a property like this, and all these folks will say the same thing, we have many like this. They have 4 parcels. You would come in, you would say either I need to reverse subdivide this, create all one, and then we'll subdivide it. This didn't happen here. We have a same instance up on West Chester Pike where a gentleman owns 13 lots. Well, yeah, some of them are tax parcels. They've been used together for years. By rights, they've merged. I do not believe that this testimony has spoke to, if in fact you don't interpret, as I perceive you should be interpreting, the minimum necessary is not just what a builder says he wants. We have a neighborhood here where there are very many small houses that are in fact not 25 feet wide, and they're not 2.5 stories high. So you can ask a builder, because the minimum necessary that also speaks to the character of this neighborhood is not a 2.5 story house with virtually no side yard setback. If you go through and look, you'll see there are the old Sears catalog homes. So I would urge you, should you make the interpretation that they could subdivide a lot that wasn't subdivided, build on a lot that wasn't legally subdivided, then the minimum necessary, I would argue, is not 7.5 feet. This house will change the character of that neighborhood. So, I'm going with what Diane is saying, which is, send this guy in to get a subdivision. And when he comes back, you can then decide if he has if the variance he's asking for, having created a non-conforming lot, are the minimum necessary. Finally, one of the things they asked for here is, will you automatically give them an extension? That has not been the process here. Building or not, if he can't get a building permit in 6 months, you have a process where he can come in and say, couldn't get the building permit within this 6 months, give me an extension. That's our ordinance. I would urge you to follow that ordinance. I believe that he has not made the argument for the granting of these variances, because a variance should only be granted under all circumstances, and he has not met that. Thank you.
Thank you. Any other public comment before we? All right, then.
Would it be helpful does the board want me to brief any of the issues or provide you with any case law on any?
No, I mean, we're not going to make a decision tonight anyway, so we're going to take this to January 20th.
I would.
Do you want me?
Oh,
to-
that's fine. Yes, I'm
You can
sorry.
supply whatever information.
Yeah.
Okay,
And as the protestants can as well.
okay. Is just legal argument, though. We're not going to be submitting other documents to the board.
Yes.
Or can
Record's
we,
closed.
so we can put in case law?
Yes.
You can speak or write to the subdivision of the properties and not
I know,
have an
that's-
argument
Oh, well, we've got that.
of the subdivision and who
So,
and what initially and
So
then.
all of the
How
protestants
was
and
this
everybody
property created on
understands,
this-
this
on
board
this
has
first, who the
45
previous
days to
owners
render
were
a
of the
decision
three
on tonight's
question.
hearing. So
Okay.
the board will take it under
I mean, these
advisement
lots were
and will
created years ago, but
reconvene
Right, was
it always
next month on the
a
20th
standalone
and
lot?
make a decision at that time.
Ever, and then was always for sale, or
Sorry?
sequence of it was this.
Sorry, I can't hear you.
Somehow was able to be sold by this person.
Most likely we'll be meeting for the zoning board at the township building, correct?
Are we talking about in
Okay.
January?
Yes.
look at
Yes.
We should be back. It will
Unless
be on the
something,
website.
unless something completely falls apart, January, we will be back in the township building. They're finishing up the carpet in the library today and tomorrow, and all the stuff will be moved back. So we should have our meeting.
and do we have the exact date of the meeting?
January 20th.
Okay, thank you.
Verify here. Yeah.
All right, thank you. All right, thank you for your time. I know you have another application.
You're not gonna make a
I'm so sorry. What are you looking for?
My back? Oh, it's on my shoulder.
It's on your
Never mind. So crazy. Oh, my God. I mistakenly thought I was gonna get home early to decorate my Christmas tree. My daughter's probably like gonna shoot me. She's 15, so she's probably okay instead of not there.
This is a lady when it's covered wood.
Oh, okay. Right. You saw it that day. Right, right. Right, exactly, exactly. That's great. All right, thank you. Okay.
I think you should.
Hey, Ken.
Yeah. No, I know when it's.
You're right.
Hey, baby, I'm getting there, almost. You good? You need a break? You good? You sure?
Tom, whenever you're ready.
Tom? You're the show. You're the middle guy. You're our star. Okay.
Yeah. Here we go. All right, we're gonna get started, everyone. Just gonna go because we have application Z 2021-43. Heather DiGiacomo, 8 Albans Avenue, Newtown Square, PA, pertaining to the subject property at 571.
Excuse me, if you are still talking, please leave the room. We have another case going on. Have some respect for the people that are here. Please go in the other room so we can continue the hearing. Thank you.
The applicant is seeking a use variance from sections 172-29A and 172-141E to allow property to be used for veterinary services. The applicant is also requesting any other relief that may be realized during the hearing process. The subject premise is located in the R1 zoning district. And we have here Mr. DiGiacomo. Okay. And
Good evening. My name is Elizabeth Naughton-Beck. I am an attorney with the law firm of Petrick and Wellman, D'Amico Brown, and Petrosa. I represent Heather DiGiacomo in connection with her request for an expansion of a special exception, which was originally granted for the property located at 571 North Newtown Road in Newtown Square.
we want to just get them sworn in.
Oh, yeah.
And Andy, the records and anyone here as a party protestant or public comment?
Chris Kaminsky, State College, I was a real estate agent.
As, is this one of your witnesses? Okay, good enough. And Mr. Sikora? All right, it's good to go. So go ahead and present your.
As my application states, we have also, to the extent necessary, are seeking an appeal from the decision made in the zoning office that indicated that the prior special exception granted had been abandoned because of a passage of time. It's our position that the special exception that was granted in 1988 runs with the land and therefore is not considered a pre-existing nonconformity that would be subject to abandonment, but I'll get to that later. The property at issue is 571 North Newtown Road. It was originally built in 1710. It is known as the James Price House. It was built on a Penn land grant by James Price. Over the years, the house has been expanded to include the part of the building that faces onto Newtown Street Road. Attached as Exhibit A1 is the posting of the property. Attached as Exhibit A2 is the deed for the property. In 1988, those owners, Raymond and Francis Giuliani, subdivided the property, selling a portion for the construction of a single-family home, which was ultimately sold. At that time, they also obtained a special exception from the zoning hearing board for Dr. Giuliani to operate a veterinary practice. Barn is a 2-story stone frame bank building, with plumbing and heating in the rooms of the first floor. Before you tonight is the request to expand the previously issued special exception granted. As I indicated, the grant of special exception runs with the land, meaning it is granted to the property, not the owner or occupier of the property. Therefore, the use is not subject to nonconformity or abandonment. No conditions were set by the zoning hearing board when it was granted back in 1988, other than it shall be deemed as an accessory use to the residential dwelling. Dr. Giuliani operated his veterinary clinic out of the barn for approximately 20 years. He passed away sometime over the summer, and the property is now listed for sale. With me, the applicant, Dr. Giacomo, plans to continue the use of the barn for her veterinary practice. She also seeks permission tonight to expand that use to renovate and build an addition adjacent to the barn for an approximately 2,000 square foot addition. At this point, I'd like to call Dr. Giacomo. Why don't you give the board your current name and business address?
Heather DiGiacomo, and my address. Oh, I'm sorry. Yes. Heather DiGiacomo, and the address of my business is 8 St. Albans Avenue in Newtown Square.
And are you the owner and operator of Newtown Square Veterinary Hospital?
I am.
And how long have you been in practice there?
In this location for 5 years.
Okay. Attached is Exhibit A3, if I can ask you to look at. Can you identify for the panel what that document is?
That is my current resume.
Okay, and does that indicate your education, experience, and work, when your work experience? Excuse me.
It does.
Okay. Now, you've mentioned in this location, you've been in St. Albans Road for the last 5 years, is that correct?
Correct.
Okay. Can you describe for the panel the nature of your practice, of your veterinary practice?
We are a small animal general practice. So we see cats and dogs exclusively during regular business hours. We are not open on weekends. So Monday to Friday with 2 evenings until 7 p.m. where they're otherwise 8 to 5. We do basic medical and surgical care for cats and dogs.
Okay, and what are your hours of operation?
Monday, Wednesday, and Friday, 8 a.m. to 5 p.m., Tuesday and Thursday, 8 a.m. to 7 p.m.
Are you open on the weekends?
We are not.
Do you board overnight?
We do not.
Do you have kennels?
We do not.
Okay, during the last 5 years, have you received any citations from the township or otherwise received any complaints from any of the neighbors?
We have not.
Okay, and over those last 5 years, have you looked around at relocating your practice?
I have been looking for about 3 years.
Okay, and why is that?
We are currently in a leased space. So my intention was, as the business got its footing, was to establish more permanent roots in the community. So my goal was always to purchase real estate and, have a long-term investment in the community, which has allowed us to grow and flourish to this point.
Okay. Turning to Exhibit A4, can you identify for the panel what that document is?
This is an agreement of sale for the property at 571 Newtown Road.
Okay. And as part of your due diligence in researching this property and making the offer, did you request information on the prior use of the barn for veterinary practice?
Yes, we submitted a right to know request and obtained documentation from the township regarding the previous zoning of the clinic that was there.
And what is your understanding of that decision?
My understanding is that Dr. Giuliani was able to operate his veterinary practice as a special use exception, and that the exception still remains in place and can be utilized by whoever were to purchase the property.
Okay. Have you had an opportunity to speak with the seller of the property as to your proposed use?
Yes, I've spoken with the Giuliani estate. There are several children of Dr. Giuliani who are representing the estate. They're involved in the sale of the property. They are very enthusiastic about the legacy of their father being carried on in the same manner that he lived there and practiced. And they are very supportive of my intentions for the land and the property.
Okay. Attached as Exhibit A6. Is this a letter that you received from Linda Giuliani?
That is correct.
And does this identify or authenticate her support that she gave you verbally with respect to your proposed use of the property?
It does.
Great. Okay, so turning to your intended use for the property as Exhibit A7, and I do want to point out, I did have conversations with Andy that at this point, we're just seeking special confirmation that the use of the property is permitted. Engineer drawings have not been done. because of the size of the property, it's a 2.29 acre parcel, that the proposed use will not seek any further relief from the zoning hearing board, meaning no setbacks are going to be required, and it is believed that there's sufficient square footage in order to satisfy the parking requirements that would be required by your township ordinances. Okay, so turning to Exhibit A7 are two aerial photographs. I believe the first one shows, am I correct, that this shows the current conditions?
That's correct.
Okay, and the second photograph shows your proposed addition with the proposed additional parking, correct?
Correct.
Okay, can you tell me who prepared this?
That was prepared by my husband, who worked for an architect.
Okay, all right. And the panels, I'm not calling him as a witness. As I said, these are not scale drawings. This is just to give the panel an idea as to what is being proposed, and with the understanding that we're running the risk of, should we get permission once we go down that path and we do get engineered drawings, that we're either going to build something that are within those limits, or we're going to be back before you. So I did ask that you identify the setback between the property line and where the parking lot would begin. Is that correct?
Correct.
Okay, and then that would show a 50-foot, 6-inch distance?
Correct.
Okay. So the proposed hours of operation that you previously testified to, will those be the same hours of operation in the new location?
They will.
And at this new location, will there be overnight boarding?
There will not.
And will there be a kennel?
No.
We've talked about the proposed use of the barn. What is your intention with respect to the residents on the property?
The residents will remain as a residence.
Okay, so to be clear, the residents will always be used for family dwelling?
Correct.
Okay. I did mention that it's a historic property, correct?
Yes.
Have you had any conversations with anyone from the Historical Society?
Yes. I had several members of the Newtown Square Historical Society come and meet me at the property, where I thoroughly explained our plans and intentions for the property. My intention as a passionate lover of historical buildings is to retain as much of the integrity and architecture as possible, while making it more functional for our use. And the Historical Commission was extremely enthusiastic about our plans, to the point where they have provided their written letter of support.
Okay, and the document marked as Exhibit A8, is that the letter of support from the Historical Commission?
It is.
Great. And in your conversations, was there discussion about you making the home available for tours or their use for the Historical Society activities?
Yes, there would be accommodation for that.
Okay. Have you made an attempt at reaching out to any of your neighbors?
Yes, all of the neighbors that received notification from the township were mailed a letter where I invited either an in-person, email, or phone conversation to discuss any concerns related to the project, and we did not receive any responses.
Okay, so those letters that were sent out have been marked collectively for exhibit as A9. Are those the letters that you sent out to the neighbors?
They are.
All right, Dr. Giacomo, in your opinion, will your proposed use of the property substantially increase traffic congestion on the streets?
No.
And do you believe it will increase the danger of fire or panic or otherwise endanger the public safety?
No.
Do you think this is overcrowding the land or creating undue congestion of population?
No.
Do you believe it will impair an adequate supply of light or air to the adjacent properties?
No.
Do you believe that your proposed use is consistent with the character of the surrounding neighborhood?
I do.
And do you think it will affect the character of the immediate neighborhood by failing to conserve the values of the existing buildings and to encourage the most appropriate use of the land?
Can you repeat that?
Sure. It was a double question. It was a compound question. Do you
break it down for me?
Your proposed use of the character of the, your proposed use of the property will affect the character of the immediate neighborhood?
Will it affect? No, it will not.
Okay. And do you believe this is an appropriate way of using the land?
I do.
And do you believe it will burden the water, sewer, groundwater, schools, parks, or other public features?
No.
Now, do you understand that as part of, if you were granted permission tonight, that you have to go through land development?
I do understand.
And do you understand that as part of that land development, you will need to go through stormwater management in order to ensure that the improvement will not impair stormwater management or cause soil erosion?
Yes,
And will there be sufficient off-street parking for your employees and clients?
there will.
And will you be providing a landscape buffering to the abutting raised residents?
Yes.
Abutting residents, sorry. And with the admission of my exhibits, that concludes my questions of Dr. Giacomo.
Just one, the residence, are you moving in that residence or become a?
I will not be living there. It will be rented to a staff member of the hospital.
Okay, so someone from the organization. will
Correct.
live, okay.
That's
Through
exactly right.
Airbnb.
Make sure you talk to Zach first. Make sure you talk to Zach.
Zach, you're still here, right?
Mr. Scora.
That was my friend.
Sorry, Rick.
That really is it. If I can, if you don't object, I'll just mix my law and fact, just so we could cut to the chase. So I don't think the township disagrees that this was a special exception that was granted. And I don't think the township disagrees that that special exception runs with the land and it hasn't been abandoned. So I think that's okay. This is why it got confusing though, and I want to just point this out and make sure everybody understands. So back in 1980, the code regarding the uses of residential properties and these types of professional offices and type uses, that's when the code was written. So this special exception was granted in 1988. So it's still the same code, okay? Now, I don't think, now, it doesn't mean it gets undone. Nobody appealed it. This is the use that was granted. So back in 1988, I don't believe they should have granted it the way they did. They did, and we'll live with that. So, and what I'm saying is, so in addition to single-family dwellings in the R1 district, R1, right? Yeah. You have single-family dwelling, public parochial schools, blah, 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 nonprofit clubs when authorized by special exception. You come down to accessory use on the same lot, customarily and incidental to any of the foregoing, and then you flip to professional offices when authorized by a special exception. No problem with that. So where I think the problem, that I have what they did back then, is that I believe that there are restrictions on these accessory structures such that I don't think they're supposed, I think the accessory structure has to be in the same build. It's not accessory structure, it's accessory use, okay? So professional offices have to be in the primary structure, not an accessory structure. And it's not supposed to exceed 20% of the gross floor area. Okay, that's not what they did, and I don't have a problem with that. So I'm not saying, hey, this special exception is gone. I'm not saying they can't use it. I do believe they can use this as the vet. And the primary concern that I had was coming into this is, well, if the owner is not going to be living here, is this going to be an accessory use at all? Because it's going to be to a staff member. I think that's got to be a condition that the owner, you know, to make this accessory, it can't be somebody who has nothing to do with the business and then a business, because now you have two primary uses, and that's going to be problematic because it changes. Instead of, you know, one veterinarian walking across and treating animals and then going back home, now you have a whole family living there at the same time. Some complete strangers are operating a business. So I think there is, to make it accessory and keep it accessory, that's tied together. So again, not objecting to the fact that this is accessory structure now. And I'm not objecting to the fact that it would probably exceed 20% of the gross floor area. The issue becomes the expansion. Okay, so the one issue is to make sure it's still accessory. The other is the expansion. I don't know what the township's position would be regarding the expansion, but I think it would have to be by variance because it's it's not a non-conforming use in that it was a granted special exception. And I just, I don't know if there'd be an objection to holding this open and you know what I mean? This.
We are under a timeline with respect to the agreement of sale. It's, when I was playing phone tag with Andy prior to the submission of the application, I wanted clarification as to whether or not whether or not I needed to appeal the decision as opposed to the abandonment issue. But in my mind, regardless, we needed to come before you anyway on the expansion. It's not a non-conforming use, so I don't know why that it would be considered a variance, as opposed to, if anything, it's a new special exception that's being requested.
Well, but that's not an issue for us to determine tonight. You're not asking for anything with regard to this addition.
No.
So if we make a decision one way or the other tonight on the abandonment issue, and I think that's the only issue before the board, then based on what I hear from the township, you understand the jeopardy of going forward with your purchase if there's inclusion of that expansion.
No, the application specifically talks about a 2,000 square foot addition and that it's an expansion of a previously.
I understand that, but that's not what you're asking. You're not asking for approval of that expansion tonight, are you? Because we don't have any dimensions or setbacks. So I want to be clear what you're asking for.
It's a use that we're requesting, not a land development. We're asking for the use, permission to use the property.
In conformity with the special exception.
As the buildings stand currently.
Well, yes, so it's there is that request, but then secondly, we would not need to come before you if the proposed structure is within all of your dimensional regulations.
Well, that's a different evaluation by the zoning officer when you make your application. So that's something that a decision will be made, and whether you have to come in front of us again is determinative of what that decision is.
Yeah, we're not anticipating needing any dimensional relief.
Okay, you're only asking that your special exception as to use is continued.
Correct. Well,
And that special exception will not change knowing that an addition is coming.
Yes.
Well, I think one other thing has to be considered. The original decision and order spoke to the fact that this was an accessory use to the primary dwelling. I think that we have to decide, or the board has to decide, when does this use no longer accessory? I mean, our definition is clear. It's a use subordinate to the main use of the land. So the main use of this land is residential. By our zoning district requirements, and also by the decision, as I read the original decision.
And that's the township's point of view with regard to the connection to the business, somebody being the residence.
And then you expand that business, it no longer accessory or residential.
Aren't there other conditions too for accessory uses on in the residential zoning district? With regard to customer traffic, signage, things
Well, I
like
think
that?
that's what Mr. Square was referring to. Under the original decision, they didn't quite follow the guidelines established for special exception, although they granted it. They did grant it, and we're not here to argue the fact that they granted it. It's just the fact that it doesn't quite meet the criteria that was established at that time.
So by us denying the application, we'd be overturning that previous lawful ruling.
Well, I think it's lawful if it's accessory, as the original order spoke to.
We also want assurance that when they purchase this property with the special exception, we hold up the special exception, that if they then proceed with this addition, that we don't, for whatever reason, change our mind.
The problem is you don't know what that addition is going to look like.
It's not an aesthetics or dimensional issue.
If it's to the use.
And that's what we're saying, that we can define the use, I believe, of that addition tonight, or do we have to have the engineering plans to define use?
Well, it's up to you.
That's what they're asking, right? They don't want to purchased this, I think, to plan to put this addition on. We say special exception, yes, it can be
I
a
clearly
veterinarian.
understand that.
And
They,
then we change our
I
mind.
mean, there's an investment here, obviously, and they want some assurances that they can expand the enterprise.
We're asking, yes, we're asking for confirmation that if we submit plans for an addition to the barn, that is going to be an extension of the,
And you're agreeing that it would be a by right application.
well, yes, that we won't need zoning relief for dimensional relief, correct? And will be an agreement that it will, the primary dwelling will remain a residential dwelling to be occupied by someone affiliated with the practice. That's the board's pleasure.
Just at a, just the question is, how are you going to guarantee that somebody from the organization is always going to utilize the residence?
It's a valid question. We would be offering favorable rent terms to encourage staff to want to live in proximity to the hospital. I have a fair number of employees who have young children who may not otherwise be able to afford to live in the Newtown Township or that Newtown school district. So this would give them the opportunity to have a relatively large home on a relatively large property in a really desirable area that they might not be able to afford otherwise.
Do you agree to a condition that the residence has to be occupied by a member of your organization?
Yes, we would agree to that.
It's complicated. The point that my primary issue, right, is number one, condition that this is to be an accessory use, there's got to be that tie between the principal residence. Sounds like we've got that. The other issue, this is my primary concern, is that expansion, right? So I don't think the board should have granted this very big back then without a variance. Yes, you have a special exception. Even though special offices are supposed to be in the primary structure, not be more than 20% floor area. So this is not in the primary structure and it's far in excess of the 20% of gross floor area. Okay, we'll live with what exists, but adding 2,000 square feet to that without a variance is a problem. And I think what the big problem becomes is what the township is concerned about is, yes, the historical use as a veterinary practice is wonderful and nobody objects to that, but is this being expanded to such a large extent and so far out of proportion with our ordinance that it's no longer consistent with a residential neighborhood, because it's all residential there. And that's, our fights in the township are, you'll recall, all up and down the corridors of Route 3 and 252, what's residential and what's not. And it's the chipping away of that and protecting the residential side. So again, I don't think that, I know that there was this issue as to whether it was abandoned or not, or whether it ran with the land or not. I think the confusion of all that, my personal judgment, I mean, I don't want to speak for the zoning officer, but my personal opinion is the reason we're looking at abandonment as being an issue is because really those criteria for a special exception weren't originally met. So it looked more like a non-conforming use than a special exception that was granted. So I think that's there's no objection to an accessory use continued as the animal hospital, accessory to the structure as approved. I think the township's position is there would be an objection to an expansion. That's of that. Certainly with, without, what's it going to look like? How's it going to be consistent with the neighborhood? How are the, is that going to increase traffic? Is it going to increase, you know what I mean? There's criteria that I think the township would be concerned about.
Well, I think there's also criteria as whether this is an appropriate use for the property, whether it's consistent with the way it has been used, whether it's detrimental to the community, to the area, the value that Dr. DiGiacomo's practice has had to the community all over the last 5 years, and the continued presence in the township. You know, the preservation of the historic building. I mean, there are a multitude of factors that play into your decision as to whether or not this is an appropriate use of the property.
I don't disagree with any of that. And I think, I don't think anybody disputes that it was used this way before. It was used this way before. I don't think, I think the Historical Society, you know, said we approve or, you know, endorse the continued use. I think it's really just, is it growing it beyond what it was, which was already beyond what it should have been.
Spot zoning, just like, I mean, it's not, but one could infer that that's sort of the appearance of this, especially with the expansion. So is there, what's the minimum required square footage? Could you occupy your veterinary practice out of the barn as it stands now?
So my current practice is about 3,000 square feet, which we've really grown out of. The upper and lower portions of the barn together are a little bit less than 3,000 square feet. So it would be essentially a lateral move in terms of the space. We could make that work. And I think that is something we would consider very highly if we were not granted the right to expand. It is not the preferable option because we really need more space, which was part of the intention of trying to purchase real estate. I will mention two additional things, if I may. One is that the Historical Commission did see, and we discussed at length, the proposed addition and changes to the site, and they were in favor of those. So it wasn't just using the property as is, but they were aware of the plans to expand. And the other is that we could potentially conceive of creating an addition that isn't 2,000 square feet. We could scale that down if that were to be something that would be more amenable to the board. That is certainly a consideration that we would be willing to consider.
How many square feet is the actual house?
2,500, I believe.
Any consideration for converting that into the practice, or is that not practical?
Because of the way that the zoning exists, we were told that that wasn't possible.
On the, I mean, I think for, you know, and I don't want to speak for the whole board, but I think for what we were originally here for tonight, I think that's a fairly simple matter, but for us to be able to say you're gonna not have a problem with, you know, doing what you're proposing, I don't think that we can't decide that tonight because we don't know what that looks like. It's not on the agenda, and it's really just the matter before us in terms of, you know, the abandonment and keeping it as is and moving forward with the veterinary practice. It has nothing to do with the expansion of the site or the addition.
The application actually was for the expansion. And then there was sort of a paragraph at the end that said, to the extent necessary, an appeal from the zoning hearing board. So I'm not sure what.
I think even for the expansion too, like they mentioned, it really is missing a lot of information. I mean, it's just dropped on a Google map image. Doesn't really give us a lot to work with to look at here.
And if, say there's a barn there now and the rendering showed that it's gonna look like the same barn and maybe it's a little bit bigger, but there's, you know, no difference in character, that would be helpful in us at least having a visual, you know, in talking through that. But for right now, you know, we don't really have any point of reference for that.
We granted this without the addition, and they can use it as is, and then they come back and apply for an addition. Does it trigger something? You have to then make a decision? Or if there's no variance requested?
I mean, I also think you should consider the 20% rule that was considered, or I assume it was considered during the original special exception. So the criteria at that time was 20% of the area of the primary building. We know that that wasn't taken into consideration. It was allowed to be performed in an accessory building, but I think the expansion, I mean, without dimension, appears to be almost double of what's currently there.
And here's the code section, I couldn't find it online, but it's 172, 172-13, that's our special exception. And code -13. Go to subsection.
Right.
Go to 4 professional offices, residential district. That's what this was granted. I'm sorry, thank you. That's what this was granted. This was a veterinary professional practice, right? Professional office. And so professional offices are, folks like, doctors, lawyers, vets, I mean, that kind of stuff. And it just says, this is professional offices and residential districts shall. This is from 1980, ordinance number 1980-16, not exceed 20% of the gross floor area, be contained within the principal dwelling of the professional, not employ more than 2 persons other than the resident occupant of the property, provide adequate off-street parking for both employees and clients, provide landscape buffering for abutting residential uses, and provide signage in accordance with our other sections of the code. I mean, so that's what I'm referring to. And so, all right, the board, the way they granted it, they said you can use this as a veterinary practice. All right, now did it exceed 20%? Yeah. Was it contained in the principal dwelling of the professional? No. All right, but they granted it anyway. Nobody appealed it. That's the rule. So no objection to the continued use of this as an accessory use, and it's going to be accessory to the professional. Maybe we won't quibble over if it's the veterinarian versus, the nurse or it's going to be an employee of the thing. It's an accessory use, but it's adding 2,000 square feet. I mean, that's bigger than the house that we talked about tonight, right? On that other lot. I mean, it's 2,000, it's substantial. And if that's going to be done, that order didn't contemplate using the existing barn as a special exception, didn't contemplate in the addition of 2,000 square feet. That's the problem that I have. I think it's a different, analysis. And, I know time is always a factor, but, if we had it, if they came back with specific criteria that, perhaps, the professionals could evaluate, maybe the township could look at something and see if 2,000 is enough for 2,000, but there's just not a lot to go on with just a drawing of 2,000 square feet. Understanding the reason there's not a lot to go on is not because it's, I understand this wasn't supposed to be engineer drawings, it's supposed to be just continued use. But again, that's not really the issue. The continued use, yes.
So you're really objecting to the expansion of the special exception, the original special exception, to the extent of the proposal of 2,000.
That's right. That's right.
That's the gist of it.
That's right. Without a variance.
Yeah, I got it.
Because then it's a different application that the township can then evaluate and the people can evaluate.
I also want to point out, I mean, here, going back to the concept that the original special exception was approved as an accessory use. If you look at the parking, typically a residential dwelling is required to have a minimum of 2 parking spaces. In the original design, go back to the original, it just had a small driveway that went to the back of the barn. Now we're going to accommodate, I don't know how many additional parking spaces. That lends me to believe that it's no longer accessory to the dwelling. That tells me, or in my interpretation, that that's becoming more of a primary use property.
Have any of the neighbors responded? Okay. I just think like Carmine Rago is the neighbor to your north.
He received it
Yeah,
in
he
his
did.
own letter.
He received.
Yeah, and it's dated November 20th, so you give him plenty of notice, but I'm surprised, like maybe if they were given the same type of plans that Andy's talking about, there would probably be a presence here of your neighbors to evaluate it. You know what I mean? It's just,
It was advertised though, right?
yeah,
As this?
yeah. I mean, and the letter includes it,
Mhm.
the 2,000 square feet. So
Mhm.
I was just curious to see what their response was, if any.
No response.
I mean, I don't know what your timeline is. I mean, is there any chance that you would continue this to get more specifics and amend the application to include the request for a
Well,
variance?
I mean, I have to take a moment to talk to the doctor, but we could amend the application. I'm assuming what Rich wants me to do is to specifically request a variance as opposed to.
Well, that's what I'm hearing. I mean, you can
Okay.
have that discussion with him.
Right. But in terms of having engineered drawings by next month, that's, I mean, and plus it also, it's.
I get that. I'm just trying to find a solution.
Well, Sam, we can approve without the addition because if we take it as is, the abandonment issue is what we can, if we make a ruling and say that's it, but if they want to propose this, they would all have to go through Andy and then take the chance of coming back here.
Right.
Right. Well, that's the risk
Right.
she's-
And if you're willing to take that risk, I think we can put a vote out for that.
Because I think we would prefer to not have a vote on the expansion issue tonight. And to give us an opportunity to come back and
Okay.
present it in a way that may be more
township.
receptive.
Hold this open.
Well, just the expansion portion of it.
I don't object to that.
Okay.
Okay.
Do we rule
Can we-
on one half of it? And does that grant you any?
Well, that at least we can go back and the doctor can decide whether she can use the property as is. I mean, now that she knows she has permission to use the property
I
as
think
is.
we would have to grant that. I don't think we said that yet, but we
Yes,
would be
yes.
hinting at it, but.
And then if the doctor wishes to move forward with an addition,
Go
we
through
can
the
come back
process.
with a new
We
and
make-
improved application.
And if
Partial
you-
ruling tonight and
I
leave it.
suggest talk to council, and once you solidify the kind of plan you want, have a discussion with, and see whether or not they're going to be on board or whether they're going to continue to object.
Why don't we just?
That's not.
Why don't we just make the zoning application A, add A or some sort of appendix.
Yeah.
Letter on the end, make that the use issue, and then we'll make a designation B for the.
Well, but if we do that and there's a request for a variance, we'd have to re-advertise. That's a new application essentially.
Yeah, but
I don't think you can do that. We can continue this without necessarily new advertising, but if we're asking for them to come forward with the variance, we got to go through that whole process.
I think the only downside is.
Right.
Yes, of course.
It's not a final ruling, so is it a? You're saying.
Well, I mean, she could merge them at some point in time and hear them back
I don't
together.
want to make it more difficult, as long as we're clear. What relief is being granted.
You understand?
No, actually. Because I mean, now he's throwing appeal period, and my understanding is if we agree to sever the application, then the township is withdrawing the objection.
Well, that's what I'm saying, yeah, yes, but what I'm
Okay.
saying, severing the application now is.
But that's not going to satisfy your needs, I don't think, based on what I'm hearing from the testimony.
Well-
You want to leave.
If you leave it open and then we have another hearing with regard to the variance, then we haven't made a decision granting one half and then you're stuck with the other half.
So I have a quick question. If we leave the record open and don't make a ruling on it tonight, can the applicant and council modify the variance requests
to include what we've talked about tonight without starting a whole new process?
Well, this is really an appeal of the zoning officer's decision.
Well, part of it was an appeal,
Right.
yes.
And second part of it, which really wasn't a request for a variance, I think you couch it in terms of another special exception of sorts.
Well, because that's the way the ordinance reads as a special exception,
But-
so.
But maybe now that you've heard this, you may understand that really request is for a variance. So we're trying to afford you the opportunity
Right, right.
of putting together so you're not at any risk if you have that opportunity. It's up to you. You need to.
Well, let
make a
me, because if I could have just one quick moment to speak with my client, but just so I understand, if we decide to modify the request in order to seek the variance, is that something that can be done next month?
Yeah, if you have some specifics about the plan.
Right.
You know, you have to carry your burden on a variance.
Understood.
I guess a simple site plan.
Yeah, if it's by right, then, then you have to deal with the traffic and impact on the neighborhood and things like that.
The township's no longer objecting to the,
Use
as a back.
accessory use.
That's. That's a real kind of basketball.
So how do we want to move forward here?
Well, they're gonna make a decision if they want to have us render on one portion of it or continue it till later time.
It's our preference to sever the application and just have tonight be, we're asking for a vote on confirmation of her use as the structure as is for her veterinary practice.
That would be your choice, not our choice.
I'm sorry, I'm not sure how I phrased it, but yes, that's what I meant.
Gotcha.
And the township doesn't object to that. Just
And
as long
you
as it's
under-
clear.
and
As
you
long as the-
understand then.
We will
that
start
moving
over.
forward with regard to the construction portion of this, that would entail a new application and a new request for potentially a variance.
Yes.
Okay. So we are bifurcating it, so to speak. So the only issue before us is the appeal of the zoning decision with regard to the continued accessory use for veterinary purposes. Right?
Who wants to modify this motion to make sure we get it right?
I'll modify the motion, everything that Sam just said.
Second.
All right, all those in favor?
Aye.
Aye.
Is that good? That's official?
Sam, you good with that?
Yep.
Okay, or-
I'll
Send you
I'll
the
send you the
ruling letter and the detailed facts and findings.
Did we need to?
Essentially,
add
it's a
the
continued accessory
must
use for
live in
veterinary
the-
purposes.
That'll be, that's how.
Wasn't that part of it?
Okay, Sam, was that part of it? Or somebody asked it?
Yeah, well,
That's all part of it, yeah.
we're gonna make that, that's gonna be a
Yeah.
condition that the accessory use continue with some member of your staff. That will be a condition. So
Yes.
everybody understands.